Now, as soon as we get a ruling, we need to right?
Sometimes we set them for trial and then have a suppression. I didn't know.
Yeah, it's not.
Before we leave here today, we'll take a look at that. I know Megan and I discussed the late brief and we discussed the brief, so we might be able to tell you what the ruling is going to say instead of trial or not today. Okay.
Thank you, Your Honor.
Okay. Thomas Brown. Commonwealth versus Thomas Brown. 18 CR 0070. Are you Thomas Brown?
Yes, sir.
What's your year of birth?
4/28/83.
1983 is your year of birth. What are the last four digits of your social security number?
2939.
Okay, what do we have here, Mr. Stockton?
This was a case we heard several months ago. Mr. Brown was in a single car accident. He was allegedly DUI at the time and hurt himself. He had surgery. I think it was C6 vertebra. Read his medical records, and we just wait and see what the court wanted to do.
Judge,
Yes.
a few months ago, this court, in settling the issue with regard to the revocation, ordered him to do 60 days rehab, provide proof to the Commonwealth that he did indeed have the surgeries and the medical issues that he spoke of. The last time we were here, we had given Mr. Judd some appointments, medical appointments that would enough. And so you continued it for us to be able to get the medical records to the Commonwealth. We've supplied those. He's still been on the bracelet well beyond the 60 days. I think he's now at 4 months or almost 4 months. And so we would ask.
What to do, Mr.
Well, he's back working.
He is. He's working at GT Trucking, and he's got one more surgery on his finger scheduled for.
What do you want to do, Mr. Stockton?
I'll continue to withdraw the motion. If he has any further trouble, I'll bring it back.
I can't understand you.
I'll just withdraw the motion. If he has any more trouble, I'll bring it back.
Okay.
That works. Thank you. Thank you, Jesse. You're free to go.
Christopher Cooksey.
Can he get the second one?
I don't know that he can, but it can be taken off.
Can we have him have,
You have any objection to that, do you, Mr. Stockton?
No.
Okay. Submit an order.
Thank you, Judge.
Christopher Cooksey. Pre-trial conference.
Yes, Your Honor. We have been working through this case. Mr. Cooksey is paying the restitution ahead of time. He paid another substantial payment, so Mr. Stockton did not have an objection to continue.
Mr. Stockton,
I don't, Your Honor. If you want to pass it for May, that'd be fine. That might be the time to get all paid.
next appearance will be May the 26th. Alfred Corcelius, sentencing.
He's probably in jail, I think.
I think he is in jail. He's up. He bonded out.
Wait till the end of the room, Your Honor. Who's reviewing?
So you need to get him in this room. David Davidson. David Davidson. So there's an active warrant. You want to be aware of that, Mr.
This is Mr. Corcelius.
Okay. Commonwealth of Kentucky versus Alfred Corcelius, 22 CR 0003 and 21 CR 00136. Are you Alfred Corcelius?
Yes, sir.
What is your year of birth?
1985.
Last four digits of your social security number?
5305.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir. Yes, sir. Yes, sir.
Is it substantially correct?
Yes, sir.
Okay, Mr. Stockton, we've been informed that Mr. Corcelius has some new charges.
He does. I think they're going to the grand jury today.
Do you,
He doesn't need to be going any too far.
well,
If you want to postpone the sentence and maybe we can work on all of it.
I'm not gonna probate it.
Just one second.
So if y'all want to renegotiate anything, anybody that I've got out on bond waiting for sentencing and does another crime is not going to get probated. So you can just tear this whole thing up as far as I'm concerned. And this man will get, he's going to serve some time. Yeah, that's pretty clear. Okay. Take him into custody. Violated his bond. Edsel Elliot. Commonwealth versus Edsel Elliot. Good morning.
Good morning, Chief.
21 CR 0046 and 21 CR 0047. You are Edsel Elliot.
Yes, sir.
Year of birth 1955.
Yes, sir.
Last four digits social security number.
9094.
Okay, we have a pretrial conference in this. So y'all got anything
We
on?
had, supposed to have one last time, and I believe somebody in his family was sick with COVID. I believe we need to set another,
What was that date again?
April 22nd.
April the 22nd is your next negotiation day, and your next court date is April the 28th. Okay.
Maybe Mike.
I'm sorry, I'm gonna interject on Mr. Elliott's behalf. He was supposed to hire private counsel, or had indicated to the court he was gonna hire private counsel. He told me today that he wasn't able to do that.
Well, your appointment will expand and continue on the case then, okay? And when these cases come up, this negotiation thing is very important in an agreement. I'm not going to turn this court into a mimic of district court or some other courts where people come up that day and start this negotiation. When you come to this court, and this applies to all lawyers, if you don't have an agreement, we're going to set a trial. Because we're working, I'm not just addressing this issue. Why hasn't it been worked on the last 6 or 8 weeks or last month since the next time? This docket has run smoothly for 10 years, and we're not going to change that. So well, that's enough said. A word to the wise is sufficient. Thank you, Mr. Elliott. Coletta Espinoza. Commonwealth versus Coletta Espinoza.
Your Honor, we have reached an agreement with the
Let me
Commonwealth.
identify her first, please. Are you Coletta Espinoza?
Yes, Your
Were
Honor.
you born in 1980?
Yes, Your
The
Honor.
last 4 digits is social security number
3441.
Okay, you're here in 21 CR 0045 and 21 CR 0044. Now, Mr. Stockton, y'all have reached an agreement, is that correct?
That's correct.
Is it the felony plea?
No, it's actually the version.
It's the version? Okay.
COVID.
Ms. Espinoza, you're represented by your counsel here today. I understand a motion has been tendered. It says you wish to enter a plea of guilty. Is that correct?
Yes, Your Honor.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Okay, you're the same person named in the 2 indictments that I announced.
Yes, Your Honor.
Is your judgment impaired today in any way?
No, sir.
Have you just discussed this matter with your attorney, reviewed all the evidence the Commonwealth has against you, and you feel like you're fully informed about your case?
Yes, Your
Are
Honor.
you satisfied with her advice?
Yes, Your Honor.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that?
Yes, Your Honor.
By entering a guilty plea, you give up all those rights, and I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law if I do not have to accept it. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea. Have you previously been diverted in the last 5 years?
No, sir.
Okay, have you had any felony convictions in the past 10 years, or are you currently on probation?
No, sir. I've never had a
Okay.
speeding ticket even.
Well, I didn't ask you about speeding.
Yeah, no,
ticket,
I've
but that's
never-
good
I've
to
never
know.
been in trouble.
I'm glad to know that. I have had a speeding ticket. Don't think poorly of me. Okay, do you understand that if you complete the diversion program, that the charges will be dismissed, pre-trial diverted, and you can have it expunged? You understand if you do not complete the diversion program, you will be brought back before the court and we will schedule a hearing after ordering a pre-sentence investigation report. If y'all will step to your left here, step to your left. Mr. Stockton's going to read the recommendation, ma'am, and make sure you listen to see if this is what you agree to, okay?
Your Honor, on trafficking controlled substance less than 2 grams, case number 21 CR 44, she'll receive a sentence of 5 years, pre-trial diverted for 5 years. She'll maintain gainful employment and pay court costs at discretion of court.
Okay. They come back over. Is that what you agreed to?
Yes, sir.
Has anybody, including your attorney, offered you any other recommendation or threat to get you enter a guilty plea? Or are you entering guilty plea because you are guilty?
Yes, sir.
One of your constitutional rights is still your desire to give up those rights and allow me to sentence you as under the provisions of the law. Is that your signature on the docket there?
Yes, sir.
Okay, well, I'm going to accept the diversion agreement, and if you'll retrieve that. Was there a DUI in this?
No, sir.
Okay, give me the diversion agreement.
Hey, Chance.
Somebody,
Good, how you
Brian,
doing?
wait.
Seen you, met you.
Just a
before. I know
second.
you a little bit. I know
No.
you real well.
Jeez, Pete. Ma'am, you'll need to meet with the probation and parole officer over here just a second so he can get a interview time set up so he can get the information, okay?
Thank
Thank you
you.
very much. Court costs are what in this case?
180.
The court costs are $180. Will you need some time to pay that?
Yes, sir.
Okay, I'll let you start paying 30 days from today, $30 a month, okay? Okay. You get these. Joseph Grider, seems to be an active warrant out, is that correct? Joseph Grider, are you here?
No, we'll have to put him in CIC as child support.
Bradley Gunter. Bradley Gunter. He should be bench warrant for Bradley Gunter. Dwight Harrell. Commonwealth of Kentucky versus Dwight Harrell, 22 CR 006. You are Dwight Harrell.
Yes, sir.
Born in 1971. Last 4 digits, your social security number 4088.
Yes, sir.
Here today for the purpose of arraignment. You're represented by counsel. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first degree possession of controlled substance. Another count. Possession of drug paraphernalia, operating motor vehicle under influence, driving on suspended operator's license, reckless driving. You understand those charges, Mr. Bailiff? Counselor, you acknowledge the identity of your client received the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pre-trial motions.
Yes, sir.
Have there been any complaints about Mr. Harrell as far as his bond is concerned?
No.
You want to set him up on the 22nd for negotiation and the 28th, thank you. The 28th for next appearance. I'm signing a reciprocal discovery order and the Commonwealth will give your attorney the information they have to help prepare your defense. Both of these dates are a condition of your bond. You understand that? Okay, you may be on your way. And it's approved. Lance Humphrey. Humble versus Lance Humphrey, 21 CR 0018. Are you Lance Humphrey?
Yes, sir.
What's your year of birth, Mr. Humphrey?
1996,
And last 4 digits, your social security number.
5319.
You're here on a probation revocation. What do you have to say, Mr. Stockton?
Evidently, Mr. Humphrey, condition of his probation, he was supposed to have a mental health assessment. I think that was done through a private doctor. He's in the Eastern State. The basis for the revocation request was a misdemeanor arrest. And basically, Officer Gunter saying he can't supervise it.
Do y'all want to move to the left here? Mr. Garner, you want to move to the left? Raise your right hand. Swear testimony about to give us the truth, the whole truth, nothing but the truth.
Yes, sir.
Mr. Stockton.
Officer Gunter, you've been assigned to sponsor Mr. Humphrey on the way.
I have.
What type of difficulty?
Okay, so on August 18th, I received a community complaint. The subject was under the influence, and there wasn't aware of what he was under the influence of. Same day, me and the assistant supervisor conducted a home visit where we drug tested him, and he wouldn't provide a sample. His actions reflected that of someone who was under the influence, but at the same time, he didn't have any of the markers of the dilated pupils or anything like that. On 8/19, we directed him to come to the office for another drug test, and he tested negative for all tested substance. So the determination was that it wasn't a substance abuse issue, but more of a mental health issue. And to follow up with the court order for the mental health assessment, we directed him to be assessed. On 11/5, subject was counseled verbally about the not having the mental health assessment. And then on 12/2/21, his mother called and stated that she was having a mental health assessment done in Somerset. On 12/3, I gave them to the end of the week to have that completed, or it had been a violation. On 12/8, I received a fax from a medical provider in Somerset regarding Mr. Humphrey stating that he can't work due to the seriousness of the medication that he was on. And then on 2/24, he was arrested for mental health warrant because he had went to someone's house saying that he was a U.S. Marshal or a Tennessee Marshal, and a mob was after him. And then when I was discussing this case with his mother yesterday, she said, I believe it might have been the day before, but she had said that he was making calls to 911 or other people saying that the mob was after to kill him again. His mother is very stressed, and she can't monitor him and his mental health issues. And because of his mental health issues, in accordance with the arrest by Deputy Lance, he's a danger to himself and others.
Cemetery was. For the citation, he was in the backdoor residence at Irby Cemetery Road after midnight in the rain.
Yes,
Then he was trying to be killed by the mob because he was a Tennessee Marshal.
yes.
Okay, you want
Yes, Officer Garner, you indicate that he had a new misdemeanor arrest, but that was a mental health warrant, is that correct?
Yes,
Okay, that was a 202A proceeding.
Yes.
Involuntary commitment. Right?
yes.
He did not commit a new crime, is that correct? Or was not charged with any new crimes? And has not been to district court on any new crimes?
I was just told that in accordance with citation DY 83668, that he was arrested on a 202A.
And that's the mental health.
Yes.
That's all I have.
Your Honor, I think based on the officer's testimony, Mr. Humphrey is suffering from a mental health crisis, but that isn't a new crime. That is a medical illness and a mental illness. I don't think that that's grounds to violate his probation, that he's suffering from a medical condition. He tested clean for the officers. He's working with the therapist.
I understand what you suggest we do.
Your Honor, you know, at this time, I don't know that my client is capable of participating in his own defense here. I do think he needs to continue to work.
What you suggest I do?
I suggest that he continue to work with his mental health therapist and do as best as he can. I don't think prison is appropriate for somebody who's mentally ill.
I wasn't suggesting prison.
Yeah.
I was suggesting evidently whatever is happening doesn't appear to be working very well.
I think maybe.
You want to move to your left here?
Maybe the only solution I can think of is take him into custody and let KCPC evaluate him if he's not competent to participate in his hearing. And see if they can have him assessed for
What
treatment.
happened to the 202A?
That must be done in district court because it wasn't
Yeah, I
out
mean-
here.
It didn't come, Your Honor, I wasn't appointed in district court. I don't think it came before the district court.
My understanding is he gets sent to Eastern State, and he just about beats them home. That's the problem. Send anybody to Eastern State or Western State.
And again, that's not Mr. Humphrey's fault. That's Eastern State's making that
I'm
decision.
not arguing that with you. I'm not arguing that he ought to be in the penitentiary. And I don't know whether he has some, obviously, it sounds like he has some mental issues. But here's the situation that I'm putting in. You say he's not competent to participate in a thing, and he's involved in some very suspicious and dangerous activity. So for his protection and the protection of the public, you think I ought to just let him walk out the door and him being hanging around a graveyard thinking that some of the mob is after him or
Your
something?
Honor, I wasn't nowhere near a graveyard.
Yeah. Oh, when you said you were with the Tennessee Bureau, you weren't in the graveyard, you were somewhere else, right?
I wasn't in the graveyard at all.
Okay.
Your Honor, what I would suggest for right now is to place him on an ankle monitor and allow him to do outpatient evaluations with KCPC, because my understanding is for an outpatient, they can get them in about a month versus I think we're out 300 days for in custody.
Wherever you want to be. It just needs to be somewhere where we know where he's at.
Mr. Humphrey, I don't really know what's going on with you. And I kind of know of your existence as who you are, but I don't have anything against you. So I'm not trying to do anything to you.
Okay.
But something's going on with you. Okay, don't acknowledge you have an attorney. Something's going on with you. And I don't want you to get hurt. I don't want you to hurt somebody. If you have, don't say anything, but if you have said the sort of things that they say you have said and goes to somebody's house, somebody could hurt you. Okay.
Sure.
So what I'm going to do is I'm going to put an ankle bracelet on you. And I want, where do you presently live?
I presently live on Liberty and Bowe.
Well, where, with whom?
I live beside my mother in a
The house
cabin.
is
Yeah.
it- It's like a little house next to your mom.
Yeah.
isn't it?
Well, I want you to be under a curfew, and I want you to stay there. You can go to church or the doctor or court appearances, or if you're, now your mother works where?
Get pizza.
Pizza Hut. Well, if she wants to take you somewhere other than that, you can go with her, but I don't want you out, as they used to say in Monroe County, gomming around. So I'm not going to put you in jail, and we're going to order a outpatient mental evaluation and continue. You need to continue to deal with these healthcare people.
But you gotta go to this. It's an added.
What's Miss Cumberland? There.
Okay, you are.
Okay.
Thank you.
Now I'm gonna ask him to stay here to the Justice Center till he gets hooked up. Can you afford the ankle monitor?
No, I can't. My
Okay, what I'm
family-
gonna do is order that the county pay for the ankle monitor because it's cheaper than, they can't take care of him in the Adair County Jail. Now, Lance, I want you to listen to me.
Yes, sir.
If you hear any voices, or if you do telling you to do something odd, or that somebody's That ain't the Lord talking to you. You understand what I'm saying?
Yeah.
You need to go talk to your mom, or you need to call your healthcare professional, and you need to get help immediately. Because everybody has problems in their life, and I'm not criticizing you, okay? But you need to cooperate with your attorney and everybody here to see we can get you, see what's going on with you, okay?
Okay.
Okay, you let him stay back there just for a while till we get him hooked up and you'll call somebody, okay? You're not going to jail. They're just keeping you back there till we get hooked up. You understand that?
All right.
Okay,
Thank you, Your Honor.
yeah. Tessa Humphrey. Commonwealth versus Tessa Humphrey. 21 CR 00153. Are you Tessa Humphrey?
Yes, sir.
Born in 1984.
Yes, sir.
Last four digits of social security number 5068.
Yes, sir.
We're on a pretrial conference.
We have an agreement, Your Honor.
Okay, is this a felony plea or pretrial diversion?
Pretrial diversion.
A motion has been made, Ms. Humphrey, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 21 CR 00153?
Yes, sir.
Is your judgment impaired today?
No.
You need to speak up a little bit.
Okay.
Have you discussed the charges with your attorney? Are you satisfied with her advice?
Yes,
Have you
sir.
reviewed all the evidence? You feel like you're fully informed about the case?
Yes.
You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel, jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, the right to appeal this matter, higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty charged against you. You understand that, but by entering the guilty plea today, you give up all those rights.
Yes, sir.
I may consider the Commonwealth's recommendation, but I may accept any range of I may apply any range of sentence allowed below. I do not have to accept the recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your guilty plea and proceed to trial. Have you previously been convicted or have previously been diverted in the last 5 years?
Yes, sir.
Do you have any felony convictions in the last 10 years?
No.
Are you currently under probation?
No.
You understand that if you complete diversion, the charge will be dismissed pre-trial, the verdict given expunged. You understand if you not fully complete diversion, you can be brought back to court. If I find that you violate the diversion program, I order pre-sentence recommendation report and pre-sentence evaluation report, and can sentence you to prison, and then you will be a convicted felon. That could be used against you in the future. You understand that?
Yes.
Mr. Stockton is going to read the thing. You step to the left, Mr. Stockton.
Your Honor, she's going to plead guilty to theft of unlawful taking over $1,000, 5 years, pretrial diverted for 5 years. She was originally going to go into drug court, but she doesn't qualify, so she's going to be supervised by probation parole, follow all recommendations. She'll get a mental health assessment, pay the court cost discretion of the court, and maintain gainful employment.
Is that what you agreed to?
Yes, sir.
Do you understand all the different things you have to do under this?
Yes.
Okay. Has anyone threatened or forced you, or you entering this plea because you are guilty?
Yes.
Okay, you understand. So knowing your constitutional rights, is it still your desire to enter this plea and allow me to sentence you? Is that correct?
Yes, sir.
Is that your signature on the documents and offer?
It is.
Okay. Yeah, I'm going to accept it upon the recommendation of the Commonwealth. You'll need to, thank you very much.
Your Honor, I made the one amendment that Mr. Stockton just indicated. The paperwork had originally reflected drug court, but it's probation and parole
Yeah,
now.
we're going to do a separate order.
Okay.
Okay, you'll need with the probation, since she's not going into drug court, she'll need to meet with the probation and parole officer over there. Give him information. Court cost is $265. Do you need some time to pay that? I'll let you pay it at $30 a month. First payment is due 30 days from today and $30 every 30 days until you pay it, okay? Can you make that?
Yes, sir.
Okay, fine.
Thank you, Your Honor. Thank you.
James Hurst. Commonwealth versus James Hurst, 22 CR 0013. Good morning.
Yes, sir.
Are you James Hurst?
Yes, sir.
You born in 1970?
Yes, sir.
Last four digits, social security number 2119.
Yes, sir.
Who's your attorney?
I tried to retain one, but I just can't afford it. I just, I was wondering if the court maybe will appoint a public defender for me.
Do you have a job?
Yeah, I'm self-employed.
Well, you can fill out a form. I'll appoint them temporarily here. And you'll fill out a form and I'll determine if you're qualified. You need to be on April the 22nd. You need to be with your lawyer at a negotiation day to negotiate, to see what's going on. You've previously been arraigned. Were y'all provided with the compliance?
With the discovery, Your Honor?
Yeah,
No.
the
'Cause he-
compliance to discovery.
Yeah, we did not get that last time.
Okay, if you'll provide counsel with a compliance discovery and you'd be on April the 22nd and your next court date, April the 28th.
22nd, 28th.
Both of them are conditions of your bond. You understand that? You need to get with the counsel as soon as you can, so you can do that. Okay?
Thank you.
Scotty Lay appears to be an active warrant. Is he before the court? Scotty Lay. Mr. Stockton, do you know?
I'll have him, yeah.
Okay. Michael E. Nethery, active warrant. Michael E. Nethery.
He's here.
Are you Michael E. Nethery?
Lee? Yes, sir.
Michael E. Nethery.
Yes, sir. Okay.
What is this active warrant? Okay, well, take Mr. Nethery into custody. And then y'all go ahead and process him, okay? Jared Norris. Jared Norris. Are you Jared Norris?
Yes.
You were born in 1986.
Yes.
What are the last four digits of social security?
8168.
Okay, you're here in 20 CR 0069. It's a pretrial conference.
We're waiting on the ruling on the arms. He's a public defender, Joseph Barnes, so we're waiting on that.
Is that Mr. Cross's case?
That's the one who's still there.
You'll be back here in court on April 28th. Okay. Sarah Page says there's an active warrant. Sarah Page. What do you know about that, Mr. Stockton?
That's what it needs to be asked.
Okay.
She's out of state.
Dale Reasoner. Doesn't appear to be before the court.
Your Honor, I have represented the Regional District Court. I don't think I'm going to be representing him, but I think he's out of state, perhaps custody, but
Okay, we'll put him in NCIC and try to find him. Amanda Reynolds.
Your Honor, Ms. Reynolds tested for flu yesterday. I furnished proof to Mr. Stockton, so we can pass that to.
Looks like she has a positive test for type A flu. Looks like she's-
How far along are you in?
Well, we either, in the next pre-trial, we either have a plea or a trial date.
You hadn't had, you already negotiation?
Yes, we have. We're close, but she got sick on me yesterday.
May be here on April the 28th.
About 22nd.
Caitlyn Riddle. Commonwealth versus Caitlyn Riddle, 22 CR 0014. Are you Caitlyn Riddle?
Yes, Your Honor.
You're here today for pretrial conference. What was your year of birth?
2001,
Last four digits of social security number?
4568.
What do you have, Mr. Stockton?
Have a plea, Your Honor. So
Yes.
Is it a
Yes.
pretrial diversion or felony plea?
Diversion, Your Honor.
All right, a motion's been tendered. Ms. Riddle, it says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No,
This is plea freely and voluntarily given.
yes.
State your full name and year of birth.
Caitlyn Riddle, 2001.
Okay, are you the same person named in indictment 22 CR 0014?
Yes,
Is your judgment impaired in any way today?
no,
Have you discussed these charges with your attorney and are you satisfied with her advice?
yes, Your Honor.
Have you had plenty of opportunity to review the evidence the Commonwealth has against you?
Yes,
Okay, you believe you're fully informed. Okay. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know that you understand these rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter in higher court if you lose. Your right to acquire the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights.
yes,
I may consider Commonwealth's recommendation, but I don't apply any range of sentence provided by law. I do not have to accept any recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea. Have you previously been diverted in the last 5 years?
no,
Do you have any felony convictions in the last 10 years?
no,
Are you under president of probation or pretrial diversion?
no,
You understand if you complete the pretrial diversion, the charges will be dismissed pretrial diverted. However, if you do not successfully complete it, you brought before the court and I violate you on those, that you have a pre-sentence investigation report done, you'll be sentenced, you'll be a convicted felon, that can be used against you in the future. You understand that?
yes.
Step to your left, please. Mr. Stockton, come up and give us what your recommendation is.
Your Honor, Ms. Riddle will plead guilty to possession of controlled substance first degree. Receive a sentence of 3 years, pretrial diverted for 5 years. She'll enter and complete the Cumberland County Drug Court Program, maintain gainful employment, and all evidence in this case be destroyed, and pay court costs at the discretion of the court.
Is that your understanding?
Yes, Your Honor.
Has anyone threatened or coerced you?
No,
You're entering a plea because you are guilty for no other reason.
yes,
Knowing your constitutional rights, is it still your desire to waive those and allow me to fix the punishment within the range permitted by law?
repeat that, sorry.
Okay, is it your desire to waive your constitutional rights
Yeah.
and allow me to fix the sentence within the range permitted by law?
Yes,
Okay. Is that your signature on the document?
yes,
Yeah, I'll accept the agreement. She's gonna be evaluated for drug court already.
No, not yet.
You want her,
She will be.
she remained free under supervision.
Yes.
I was filling in the phone number for drug court. I've attached the order, Your Honor.
How much? Was there a DUI in here? Was there a DUI in that last case? Have we had a DUI this morning? I was reading over the documents last night. I guess I want to make sure I watch for those for the other warning on the thing. Okay. She's entered this plea here. Who is responsible for her, for supervising her until she gets, has she been voted into the drug court yet?
No.
See, I mean, we got a time period here in
Yeah,
between.
she has to be entered the plea before they can even assess her.
Yeah, but she's still,
I guess she'd be under probation until the drug court accepts her.
y'all will take care of her till then.
That's how we've been doing it, Your Honor.
Okay. Well, I asked you that because I was talking to some other judges and there was a little pushback on it. They call it a no man's land there, a plea to, you know. Yeah.
Your Honor, she would need some time to pay the court costs. What rate should she pay it at?
Do what?
She needs some time to pay the court costs. What rate should she pay it at?
How much is the court cost again? Can you pay $30 a month?
Yes, Your Honor.
Okay, pay $30 a month, your first payment, then do 30 days from today.
Thank you.
Yeah. She was the one. Don Rodriguez. Commonwealth Kentucky versus Don Rodriguez, 22 CR 007. Are you Don Rodriguez?
Yes, sir.
Born in 1980?
Yes, sir.
Okay. Last four digits, social security number of what?
3131.
We're here for a pretrial conference. You have an agreement?
Your Honor, Mr. Stockton wanted to check on Miss Rodriguez a little bit more before making another offer. She is being supervised out of Tennessee and has been for a while. We just want to make, or, well, it's a case out of Tennessee. She's being supervised by Officer Garner.
Yeah, I found out recently, she's on parole out of Tennessee, so that'll take her to negotiations. We can have one more time.
April the 22nd for negotiations, and your next court days, April 28th, and both of them are conditions of your bond. Do you understand that?
Yes, sir.
Emmanuel Santiago Vega. Morning, sir. Are you Emmanuel Santiago Vega?
Yes,
What's your year of birth?
1982.
Okay, and last four digits, your social security number?
451.
Okay, you're here today on the pre-trial conference. You're represented by Ms. Perigin. Have y'all had negotiations in this case, Ms. Perigin?
Yes, Your Honor, and we have reached an agreement with Commonwealth.
Do what?
We have reached an agreement with
Okay,
Commonwealth.
is the agreement a felony or a pretrial diversion?
It will be a felony.
Okay. A motion has been tendered, sir, that says you wish to enter a guilty plea. Is that correct?
I'm sorry.
A motion has been tendered that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
You're going to have to say verbally
Yes.
because it's voice activated. Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes. Yes, sir. Yes.
Okay. Are you the same person named in indictment 21 CR 0042 and 21 CR 0043?
Yes, Your Honor.
Okay, have had plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, Your Honor.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you've been fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under Kentucky and the United States Constitution. I need to know that you understand those rights.
Yes, Your Honor.
You have the right not to testify against yourself. No one can make you say anything. The right to speak trial by jury, the right to be represented by counsel for jury trial, the right to confront and cross-examine all witnesses testify against you, the right to produce evidence, the right to call witnesses in your favor and have process issued to compel or attendance. You have the right to appeal this matter to higher court if you lose, the right to require the Commonwealth prove on a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea, you give up those rights. And I may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report from probation and parole. In the event that I decide not to accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. If you'll step to your left here, Mr. Stockton, what's your recommendation?
Mr. Santiago Vega will plead guilty in 21 CR 42 to trafficking controlled substance over 2 grams. He'll receive a sentence of 5 years. He'll serve 120 days. Balance will be probated for 5 years. Once he gets out of custody, he'll maintain gainful employment. All evidence in this case will be destroyed. He'll pay court costs at the discretion of the court.
Is that your understanding?
Yes, sir.
Okay. Are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
Okay. Knowing your constitutional rights, I've explained to you, is it still your desire to enter this plea and allow me to set the punishment? Is it still your desire to enter this plea and allow me to set the punishment?
Yes.
Of course, if I said it higher than you've agreed to, you can withdraw your plea, okay? You understand that after this plea, any future convictions of felony could be enhanced as far as penalty under the persistent felony offender law. You understand that?
Yes, Your Honor.
Is that your signature on the document there?
Yes.
Okay, I accept the plea or pre-sentence investigation report. You'll be back down here for sentencing on, yes, April 28th. They could probably get done today. Okay? So custody of jail.
I believe that's for home incarceration, Your Honor.
I thought he'd serve 120 days. Was 120 days home incarceration, Mr. Stockton?
Yeah, it's home.
Okay. Okay, you need to go over and meet with the probation parole officer and give him information, okay? Patrick Sharp. Good morning.
We have a resolution of this one. He's entering a misdemeanor
Commonwealth
plea.
of Kentucky versus Patrick Sharp, 21 CR 0053. Are you Patrick Sharp? 1996, last 4 digits, social security number 4954. Is this a felony plea or a pretrial diversion?
It's a misdemeanor plea, Judge.
Misdemeanor plea. Okay. Well, you have certain rights under the Kentucky United States Constitution. Before I can accept any plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. The right to call witness and produce evidence, right to fill this matter to higher court if you lose, your right to require the Commonwealth to prove on a reasonable doubt that you are guilty. You understand that by entering guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept it. This is a misdemeanor, so yeah, I can sentence you today. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea. You understand that? Okay, move to your left a little bit more. Mr. Stockton, what is the?
Yeah, Your Honor, just for a little background, this is an undercover buy from June of 2019. Since then, Mr. Sharp had another case. He completed drug court and graduated, and he's been doing real well. So that's the basis for the reduction. It's possession of controlled substance, 2nd degree, 12 months probated for 2 years supervised, pay a $200 fine and court costs, and the evidence be destroyed in this case.
Is that what you agreed to?
Yes, sir.
Okay. Well, is that your signature on the document?
Yes.
You got a judgment?
I did, Judge.
Okay.
Motion judgment.
I'll accept the agreement. Sign the judgment.
Oh, these other people? Yes, they're in jail.
Yeah. Clerk has brought to my attention that I charged him a $500 public advocacy. Has he already paid that $500? No. I will, since he appeared with private counsel, you just submit an order for us and I will leave him with that, okay?
Thank you, Judge.
Vivian Stahl,
I didn't know.
I'm over Kentucky versus Vivian Stahl, 21 CR 0052. Are you Vivian Stahl? What's your year of birth?
1979,
Okay, and last 4 digits of social security number.
3331,
2331?
3331.
Okay, it's on here incorrectly. Let's make a note that her social security, last 4 digits of social security number are incorrect. Can you fix that? Okay. What do you have here?
We have a plea agreement, Your Honor, for a felony, or I'm sorry, a pretrial diversion.
Okay. Ms. Stahl, a motion been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 0052?
Yes, sir. Yes, sir.
Okay. All right. Is your judgment impaired today?
No, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Had plenty of time to review all the evidence in the case. You feel like you're fully informed?
Yes, sir.
Okay, you understand that you do not have to enter a guilty plea. You have certain rights under the United States and Kentucky Constitution. I'm going to read you those rights and you can acknowledge whether you understand or not. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial with jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge against you. You understand that entering a plea today, you give up all those rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I have my range of sense provided the law. I do not have to accept any recommendation. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, then you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Have you previously been diverted in the last 5 years?
No, sir.
Do you have any felony convictions the last 10 years?
No, sir.
Are you currently on probation or pretrial diversion?
No, sir.
You understand that if you fully complete the diversion program, the cases would be dismissed pretrial diverted. However, if you brought before the court and I find you violated those, I'll order a pre-sentence investigation report. You'll be a convicted felon. And that conviction will be used against you in the future
Yes,
for
sir.
the felonies. Okay, you understand all that?
Yes, sir.
You step to the left, Mr. Stockton or Ms. Anderson, you want to give the recommendation?
Yes, upon a plea of guilty to trafficking in a controlled substance, second degree, the defendant shall receive a sentence of 3 years, serve 60 days, home incarceration, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole. Then it shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained.
Is that what you agreed to? Okay, you want to come back around here? Plead guilty because you are guilty and of your own free will, you're entering this plea.
Yes.
Is that your signature on there?
Yes.
Okay, well, I will accept. Sign the diversion agreement. You'll need to go over here to the probation parole officer, give him the information necessary so he can start file. Okay,
Your Honor, she would need some time to pay court costs.
what are the court costs in this case? 180. I'll allow you to pay it $30 a month, starting 30 days from today.
Yes, sir.
I'm going to stop here just for a second. Got 2 or 3 more. I guess we have the Adair County special judge case. Let's go to Pulaski County. Pulaski County, are you on the line? Pulaski County?
They are not.
They're not. How about Taylor County? Mr. Caldwell, until your case is called, Mr. Caldwell, you need to turn your camera off, okay?
Yes, sir. Good morning, Judge. This is Taylor County.
Okay, thank you very much. Aaliyah Hurt, is that how you say Aaliyah? Ayla, okay. Hurt, we're here for pretrial conference. Mr. Johnny Bell. Mr. Bell, are you there?
Yes, Your Honor, I'm here.
Ms. Hurt, what's your year of birth?
91
And the last 4 digits of your social security number?
2018.
Okay, Mr. Stockton?
Yeah, I'm moving to dismiss that case without prejudice. She's a special.
Okay, there's been a motion by the Commonwealth to dismiss without prejudice the charge here in Cumberland County against Ms. Hurt. Is that correct, Mr. Bell?
Yes, Your Honor, that's correct.
Okay. Okay. Case is dismissed here in Cumberland County. Amy McFaul?
Yes.
Versus Amy McFaul, 21 CR 0036. You Amy McFaul?
Yes, sir.
In 1999.
Yes, sir.
That's 4 digits of social security number or what?
1722.
Mr. Stockton, you can stay in here and do this in this courtroom, Mr. Stockton, if you want to, because we pick it up. Thank you.
We approach on this one.
The problem is with broadcasts.
It's a motion for a vote, but I'd like to have the same released, Your Honor.
Okay, well, just tell me what this is. Ms. McFaul has identified herself. Now you have filed a motion to have a diversion revocation. You have a recommendation on the record.
I'd recommend that she be sanctioned by the court for a violation, give her credit for time served and be released, Your Honor.
Okay, how many days does she have in?
I don't know.
Do you have any other restrictions on it?
No, she just needs to be available to her for supervision with her officer.
Okay, is she under probation and parole?
Yeah, she's being supervised by Jennifer Nagel out of Campbellsville.
She needs to report to her probation and
That's
parole
correct.
officer upon her release, correct? Okay, Ms. McFaul, Commonwealth has recommended that instead of revoking your diversion, that I count the days that you spend in as sanction and order you released today and for you to go report to your probation and parole officer in Campbellsville. You understand that?
Yes, Your Honor.
Okay, you be careful because you're like, got 1 foot in the penitentiary and the other one on a banana peel. You understand what I'm saying? Okay, thank you very much.
Thank you.
Taylor County, I believe that finishes us. Thank you for your cooperation.
Yes, sir. Thank
Let's
you.
go back to Pulaski County. Commonwealth versus Kevin Stark. We're here for sentencing. Mr. Caldwell, you can turn your camera on there.
Thank you, Your Honor.
Are you Kevin Stark?
Yes.
Sentencing. Your year of birth, 1980.
Yes, Your Honor.
Last 4 digits of your social security number are 0.
0378. Yeah.
Have you had an opportunity to look at your pre-sentence investigation report done by probation and parole?
I'm sorry. Could you say that again?
You had an opportunity to look at your probation report done by probation and parole.
Yes, Your Honor.
Is it substantially correct, Mr. Caldwell?
It is, Your Honor.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty of wanton endangerment, 2 counts, he shall receive a sentence of 5 years to run concurrently for 5 years. On the plea of guilty to assault, 2 counts, he shall receive a sentence of 5 years to run concurrently for 5 years. On the plea of fleeing and evading, he shall receive 5 years. The 3 5-year terms shall run consecutively for a total of 2 years, probated for 5 years. Probation is to be supervised, shall be released today, and shall receive credit for time served. Now, what is the court cost? Okay, now there was a DUI in this case, and sir, you do acknowledge the fact that you understand that in a DUI that could be used against you in the future. You understand that, don't you?
Yes.
Okay, and as well as these felony convictions, they could be used against you in the future. Both of those to enhance your sentence. You understand that?
Yes, Your Honor.
800 and what? $880 court costs. Are you gonna need some time to pay that?
Yes, I would need some time to pay that.
We'll allow you to pay it at $100 a month, starting 30 days from today. When will he need to meet with the probation and parole officer?
Tomorrow at noon, Your Honor.
To what?
Tomorrow at noon.
Tomorrow at noon? Okay, you'll need to report to Columbia to the probation and parole office tomorrow at noon.
Your Honor, I'm sorry to interrupt. We were told that we needed to leave the area, and I've made arrangements to immediately, upon release from jail, to leave the state to my Florida address and to contact probation there. The way it's worded in here.
Well, let me tell you something. You listen to me. I'm telling you what you're going to do. You have to report to the probation and parole officer here for them to set up a case number so they can transfer you to Florida and be supervised there. Okay. Is there anybody up there that can see him this afternoon?
Yeah, Your Honor. I can, he can go to the office today and I can contact somebody to speak with him.
When you get released today, go to Columbia to the probation and parole office, and they will take the information and we'll make a special deal with you. You go there, you give them the information, they'll sign you up there today. Okay.
Kevin, I'll call your wife and give her that information on where to take you in Columbia today, as soon as you're released.
And is it possible to get that 30 hours community service worked on?
We'll talk to probation and parole about that. That's just a recommendation.
Is there anything else?
That's all I have, Your Honor.
Okay, thank you very much. Thank you, Pulaski County, for your cooperation. Megan, is it time to finish my in-person docket here before we go to Adair County?
Yes, you've got 15 minutes before Derek.
Okay, thank you. Seth Staley. Seth Staley. Commonwealth versus Seth Staley, 21 CR 0050. Are you Seth Staley?
Yes, Your Honor.
Okay, you're here on a pretrial conference. What do you have?
Your Honor, we have an agreement for a pretrial diversion.
Okay, Mr. Staley, are you born in 1977?
Yes, Your Honor.
Last 4 digits, social security number 7119.
Yes.
Motion been tendered, says you wish to enter a pretrial diversion. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person named in indictment number 21 CR 0050?
Yes.
Is your judgment impaired today?
No.
You had plenty of time to discuss this matter with your attorney and review the evidence. You feel like you're fully informed and you're satisfied with her representation?
Yes, Your Honor.
Okay, you have certain rights under the Kentucky United States Constitution. Before I can accept your agreement, I need to know that you understand those rights. I'm going to go over the rights and at the end of it, you can acknowledge whether you understand it. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter, higher court if you lose, your right to require a Commonwealth with unreasonable doubt that you guilty charge against you. you're instead of entering a guilty plea, that you give up all those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided, but I do not have to accept any recommendation. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Now, have you been previously diverted in the last 5 years?
No, Your Honor.
Have you had any felony convictions the last 10 years?
No, Your Honor.
Are you presently on probation or pretrial diversion?
No, Your Honor.
You understand if we complete the pretrial diversion, the charges will be dismissed, pretrial diversion, you have an expunged. But if you do not successfully complete the diversion, you'll be brought back before the court and the court will schedule a sentencing hearing. You stand to the left here. Mr. Stockton or Miss Anderson, or need to speak up just a little bit, Miss Anderson, because I'm having a hard time hearing you. Okay, go ahead.
Upon a plea of guilty to trafficking in a controlled substance, second degree, the defendant shall receive a sentence of 3 years, serve 60 days home incarceration, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky. The defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole. The defendant shall obtain gainful employment or do a minimum of 30 hours community service until gainful employment is obtained.
Is that what you agreed to, Mr. Staley?
Yes, Your Honor.
Plead guilty because you are guilty?
Yes.
Okay. Knowing your constitutional rights is still your desire to let the court to set the penalty within any range permitted by law?
Yes.
Okay. Is that your signature on the document?
Yes.
Shall accept the agreement and sign the diversion. You'll need to, what are the court costs in the case? 180. Do you need some time to pay that?
Yes.
I'll let you pay it at $30 a month, starting 30 days from today.
Your Honor, he had one question. I just wanted to make sure I could get it clarified for him. He is to do home incarceration. He was hoping to work to help pay for the cost. Would that be approved on home incarceration if it's a public job?
Where's he gonna work?
I'm gonna try Henderson Creek.
Well, when he gets to that point, then I'll consider signing the order when he gets a job.
Okay.
Okay, if he has certain hours set, and you'll know where he is, okay?
Thank you, Your Honor.
Okay. To the probation parole officer. Amy Stinson. Cumberland versus Amy Stinson, 21 CR 0048. Are you Amy Stinson?
Yes, sir.
Born in 1981?
Yes.
Were you born in 1981?
Yes.
Last 4 digits, your social security number 5671.
Yes, sir.
We have a free trial conference. That's what we have.
Your Honor, if we can just continue her case.
Yeah, I will continue it. Let me, and then the Commonwealth might move to dismiss or. Commonwealth versus Ashley Stotts, 21 CR 00150. Are you Ashley Stotts?
Yes, sir.
You need to say something.
Yes, sir.
Okay. We have a voice activated microphone and that doesn't get it. Okay. Were you born in 1984?
Yes.
Last 4 digits, social security number 8511.
Yes.
Okay, we have a pre-trial conference. What do you have?
Your Honor, there's extensive records we've been trying to get through on Ms. Stotts. I spoke with Mr. Stockton and asked if we could pass it over to the next motion date and give us time to go through all these records and then go through them with Ms. Stotts. She takes issue with the.
What is the charge?
A welfare benefit. So there is a lot of records.
Move over this way.
More precisely, SNAP benefits, I think.
How much is involved?
7,000, I think, 7,000 or 8,000. Yeah.
What kind of date would Cumberland versus Brian Thompson, 20 CR 00066. You're here for sentencing. Are you Brian Thompson? Okay, have you had an opportunity to look at the pre-sentence investigation reported by the probation parole? Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon plea of guilty, possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation should be supervised on plea of operating motor vehicle. The alcohol content at 0.0 under the influence, he shall pay a fine of $200. Shall be agreed to be assessed by Social Services Commission and recommendation. What did fine and court cost in this case? What? $850. Now, before I sign the documents on this thing, I want to make sure that you understand that when you plead guilty on a felony case, that could be used against you in the future. You understand that?
Yes, sir.
And also the DUI can be used to enhance in the future. You understood that when you pled, correct? Is that correct?
Yes.
Okay. So you need some time to pay?
Yes.
I'll let you pay it $60 a month, first payment being 30 days from today. You need to meet with the probation parole officer. Andrew Weiss. Amel versus Andrew Weiss, 22 CR 0011. Are you Andrew Weiss? Born in 1998. Last 4 digits Social Security number 9992. It says pretrial conference.
Your Honor, Mr. Weiss came to our last settlement conference. He had indicated he was trying to hire private counsel. He has been unable to do so, so would like to keep me as his attorney, Your Honor, if we could reset for another settlement day.
You'd like to do what?
If we could reset for another settlement day, he was unable to hire private.
Well, it says here his surety is requesting come off the bond. What is that?
The surety came in.
Who is surety? Surety on the bond here?
When they come to me, do I punch on another attorney?
Ma'am, do you wish to come off the bond?
Yes, sir.
Okay, you're relieved.
Thank you.
You're in the custody of the jailer. Carol White. Commonwealth versus Carol White, 21 CR 00132.
Yes.
You born in 1972?
Yes, sir.
Last 4 digits, Social Security number 0768.
Yes,
What do
sir.
we have here? It says motion for, is it shock probation?
No, I'm asking that you be placed on supervised probation through the probation parole office. She was a second grade court and didn't qualify, so I'm asking
Okay.
you to supervise the probation parole.
Can you accept her?
Yes, Your Honor. She's actually already been transferred to initially compact Tennessee, so she's already been accepted by Tennessee as well.
Okay, well, just give me an order. Okay, and we'll take care of it.
You just keep doing what you're doing and reporting like you're supposed to. Okay? She needs to-
Nicholas Ray. You make sure you have her address so we can send her a copy of that order. Nicholas Ray.
Yes,
Mr. Ray, were you born in 1999?
yes, sir.
Last 4 digits of your social security, 1919.
Yes, sir.
The grand jury of Cumberland County has charged you in case number 22 CR 0016. You're here today for the purpose of arraignment. You have the right to remain silent. You are represented by counsel. If you have any questions, step away from the podium and ask him. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, the first degree possession of drug paraphernalia, possession of marijuana, public intoxication, criminal trespass in the 3rd degree. You understand those charges? Bailiff. Counselor, you acknowledge the identity client received indictment, wait formal reading, arraignment, and plea not guilty, reserving all pretrial motions.
Yes, Your Honor, and I discussed this previously with Mr. Stockton. I believe we're good to set this for negotiation on the 22nd with the pretrial, the 28th, I believe.
That's correct. So I'll enter in order. Both of those are conditions of your bond. You understand that?
Yes, sir.
Okay.
And will both those be at 9 a.m., Your Honor?
Yes.
Okay.
Thank you, Judge.
Yeah, thank you. Now, we have anybody else on the live docket here?
Arms is still here.
Andrea Anderson. There was supposed to be some work being done on that. Yeah. Was there anybody else after that?
Your Honor, Mr. Arms is still in the courtroom. We were going to revisit him at the end of the day.
Okay, Commonwealth of Kentucky versus Andrea Anderson, 21 CR 0080 and 21 CR 00115. Are you Andrea Anderson?
Yes, sir.
You were born in 1988.
Yes, sir.
Last 4 digits, social security number 1610.
Yes, sir.
Okay, is this an agreement of pretrial diversion or a felony plea?
Felony, Your Honor.
Okay, a motion has been tendered according to your counsel, says you wish to enter your plea today. Is that correct?
Yes, sir.
Are you currently on influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in the indictments 21 CR 0080 and 21 CR 00115?
Yes, sir.
Is your judgment impaired today anyway? Have you had plenty of time to discuss this matter with your attorney? You satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Do you believe that you've been fully informed about your case?
Yes,
You
sir.
understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights.
Yes, sir.
You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. Right to require Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. I do not have to accept their recommendation. Prior to accepting the recommendation, I'll be await the pre-sentence investigation report by probation parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that? What is the Commonwealth's recommendation?
Your Honor, on 21 CR 115, she will plead guilty to trafficking in a controlled substance first degree, less than 2 grams, receive a sentence of 5 years. 21 CR 80, she'll receive a sentence of 3 years on possession of controlled substances. Those two sentences shall run concurrently for a total of 5 years. She'll serve 180 days home incarceration, probated for 5 years, supervised. She'll enter and complete the Cumberland County Drug Court Program. All evidence in this case be destroyed. She'll maintain gainful employment and pay court costs at discretion of the court. And she will get credit for time, sir.
Okay, you want to move back over here, young lady? Is that what you agreed to?
Yes, sir.
Has anyone, including your attorney, offered you any other recommendation or benefit, or have you been threatened or coerced by anyone?
No, sir.
You enter the guilty plea of your own free will because you are guilty for no other reason.
Yes, sir.
Knowing constitutional rights, I've explained still your desire to continue to allow me to sentence you within punishment range by law. You understand a guilty plea on any future guilty plea or conviction on any future felonies could be enhanced because of this conviction. You understand that?
Yes, sir.
Is that your signature on the document? Okay, I'll accept that. We set the sentencing for April the 28th. You need to go speak to the probation parole officer, okay?
Your Honor, Mr. Arms, I believe is about all we've got left in the courtroom. I think he'd be released. You were going to discuss that or?
Joseph Arms. Yeah, I'll get an order out on this within 10 days. And then so this case and the companion case will be set for April the 28th, next court date. If there's something involved in an order that suppresses, and the Commonwealth can inform me if whatever it is that we suppress is sufficient to prohibit us from proceeding on the case, then I will dismiss the case. If otherwise, he'll be here on the 28th. Okay.
Thank you, Your Honor.
Yeah. Is there anything else? Is it all the live docket? go to Adair County. And what's the progress? Did the gentleman show up?
We're still waiting. I think he's on his way, but
Okay.
yeah, he hasn't arrived yet.
Bradley, he was one of those running like, he's here now. You had furloughed him last month to go take care of his mother. He's supposed to serve time. And he told him to come back today, see if he's going to serve his time for releasing. But released him and he didn't he just wanted to see. That's still in effect also.
Mr. Stockton? Mr. Stockton?
Yes, Your Honor.
You have this Bradley Gunter.
Yes.
He had been released to come back. We decided whether he was going to, and he's in the courtroom now.
Okay, I'll be right back. Yeah.
Mr. Wright, I'll be right with you.
Yes, sir. Okay.
Mr. Gunter, Stockton is joining us. Mr. Gunter was released from custody on February 25th for a 30-day furlough to allow him to take care of his mother. And then he was going to return today, which he has to determine whether he returns to custody or to serve the remainder of his sentence or his release. What's the Commonwealth's position?
Well, he had a 6-month sentence. I don't know how much of that he's got in.
He had, I'm trying to find the PSI, Your Honor. He had a substantial amount of credit. He was very close.
We also has a hold out of Tennessee.
I took care of those.
Well, I'm just telling you, they got a
papers up
hold.
here.
I'm not saying you haven't taken care of them. You know, I'm just saying there's a hold.
He's cooperating up here for the probation officer and doing everything he's supposed to. You say you answered the FTAs in Tennessee.
Yes, they actually pulled me over and had to serve FTA in Ventures County. They had another one in Cookville, and so they sent me to Cookville.
I'm going to take a chance on him if he's cooperating with probation for all doing what he's supposed to.
So we'll continue his probation, but I cannot release him today because he's got a hold and I have to honor the hold. So you need to call down there and make sure they get the papers up here. So
Do
he's
you know which county it's from?
Ventures County.
Do you know what the date was on it? It should be took care of already.
Well, when you get to the jail, you'll have to call Centers and they'll send the paperwork up. And
Well,
Can you just?
who did you drive yourself up here
My
today?
mother drove me.
She here?
Yes.
Well, I tell you what we'll do is we'll hold you here before we transport you for a while. Okay, give you a chance to call down there and see if you get it straightened up and the paperwork come up.
Call up here.
That's what he's saying.
Yeah, as a matter of fact, I'll let you go out, go right out there in the lobby and call her and have her come up here.
Okay, thank you so much.
Is she down in the lobby or outside?
I'm not sure. She was right here, but I'm not sure. She might have went back.
She's what? Have her just go down and bring her up here. And you just sit down in that chair right over here till they get up here, okay? Yeah, we got Michael Nethery that we served the warrant on. Mr. Stockton.
I'm here.
Does that finish the live docket? That finishes the live docket. What, Mr. Wright, what do you have?
Judge, I have
James Drew Griffith for final sentencing. He's on Zoom with his attorney. And then I think I'm also appearing on Nathaniel Christian Jones probation revocation. So one's, you're a special judge on James Griffith. I'm the special prosecutor on Christian Jones.
Okay, I've got, is Mr. Griffith in the Adair County Jail?
No, he's on Zoom, Judge.
Okay. Well, what about your special prosecutor case? Who was that person?
Is it Nathaniel Christian Jones or Christian Nathaniel Jones?
I've got a motion on it too. We both got motions to revoke on.
He's there and he's at the Adair County Jail, Your Honor.
Okay, we'll get to him then. We'll come back to Mr. Giant to Adair County Jail. Adair County will be with you in just a moment. We've got one other live matter. Let's go ahead and pull up Adair Circuit Court 20 CR 00139, Commonwealth versus James Griffith 20 CR 00139. This is a sentencing. I have the pre-sentence investigation. Are you James Griffith?
Yes, sir.
There you are, Mr. Are you James Griffith? Mr. Griffith, what is your last four digits of your social security number?
It's 9166.
Your year of birth?
1986.
Okay. Now, I have the pre-sentence investigation report. Have you had an opportunity to review this with your counsel?
Yes, sir.
Is it substantially correct, counsel, according to the review?
Your Honor, there were one or two mistakes, mostly just some dates that needed to be clarified. I emailed probation and parole this morning with those corrections. I emailed Catherine Stone, the PSI writer, this morning. But there's nothing of substance that needs to be corrected.
Okay. Mr. Griffin, is there any reason then why he should not, subject to those changes, why he should not be sentenced?
No, Your Honor.
Okay, and 20 CR 00127, Mr. Griffith shall receive 2.5 years for possession of controlled substance, 12 months possession of drug paraphernalia and public intoxication, 30 days to run concurrently for 2.5 years. Under 20 CR 00139, he will receive 5 years on trafficking, first degree, 12 months on possession paraphernalia, 12 months on possession, 12 months on possession, second degree. The other one was third degree. Rear license not illuminated, says minimum fine. I'll waive the fine on that situation. All those shall run concurrently for 5 years. The 2.5 years under 127 and the 5 years under 139 shall run consecutively for 7.5 years, probated for 5 years under supervision. Now, the court cost up there, what would the court cost be here? I don't know what the court costs would be. What this would just be for felony charges. Just give a ballpark figure. Well, I think it's more than that, but since I'm embarrassed by not having it, I'll just do $200 court cost and waive the fine on the rear license. And will you need some time to pay that, Mr. Griffin?
Yes, please.
Okay, I'll let you have pay it $50 a month. The first payment being due in 30 days. Okay. You'll need to go to probation and parole office there in Columbia. When will he need to be there in Columbia?
Tomorrow at 3, Your Honor.
Be there tomorrow at 3 o'clock. Okay.
Yes, sir.
Be sure you're there on time and get off to a good start.
Okay.
Okay. Mr. Wright, is there anything else on that case?
Judge, the only thing I would add, I had emailed this morning 2 proposed forfeiture orders. There's some cash and drugs in one case and drugs and contraband in the other case. I sent those to Ms. Thompson and copied Cameron Griffith on those. I would just ask if there's no problems with those, that they be signed and entered along with the judgment.
Okay, I'll do that.
No objection.
Okay, no problem.
That's all I had on that case, Judge.
Okay, now let's go to the Adair County. Wait, we got one case left here. Adair County will be next. We got Michael Nethery. He's here for the purpose of arraignment. You have an attorney, Mr. Nethery? Public advocacy. Are you Michael Lee Nethery?
Yes,
What are the last four digits of your social security number
8105,
and year of birth?
7464.
You're represented by counsel. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with trafficking in controlled substance, first degree, and driving on a suspended driver's license, being a persistent felony offender as far as trafficking is concerned. You acknowledge the identity of your client, receive the indictment, wait for reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, you shall be here on the 22nd for a negotiations, and then on the 28th for your next court date. Now, what's the situation on pretrial on this? He hadn't been served. Pretrial, are you on the line?
Yes, I've already put him in and his assessment is moderate. It appears he made a property bond in district court. It was either 5,000 or 10,000. I'm not for sure which one.
Okay. Were there restrictions on his driving privileges?
Yes, there was do not operate a motor vehicle, no new arrests or violations, the standard.
And when was this indictment returned?
2/24/22.
Yeah, Mr. Stockton, you have anything to comment? Anybody that's been gone that long and then just shows up on court day, it kind of raises my suspicion.
Yeah,
As far as
I don't know.
you
I
have
know
anything to
it's a
say about
trafficking amount. He had several grams of meth on him when he was caught. And
Well, I'm gonna put you a $50,000 property bond. And then when you're released, there'll be a ankle bracelet on there, okay? Thank you very much. Okay, let's go to Adair County. Mr. Wright, which one of the cases were you involved in?
Judge Christian, it's actually Christian G. Jones. I think I misstated his name, 19 CR 84.
Okay, it's talking about. Yeah, I can't tell which one of these, both of them are Cumberland County cases.
Yeah.
Are you on the 2019 case, Mr. Wright, or the
Yes.
2020? Okay,
Yes, 19 CR 84.
okay. Commonwealth Kentucky versus Christian Jones, 19 CR 0084. It says Mr. Poindexter is of counsel, but he's not.
I think he is on 19 CR case, Your Honor, and I was appointed on the 21 CR case.
We'll come out on 19.
yes, Your Honor. Myself, Ms. Costello,
And you need to move away until I, there you go.
Okay. He's up for revocation of both cases. And Ms. Costello has met with him. And so I'm just going to let her handle both revocations. Because she handled the original case.
Well, I've got two different prosecutors, so I'm going to have to handle these cases separately. Now, y'all can collaborate. I've got a special prosecutor on 0084, and he's on the line. You're listed as counsel.
Yes, sir.
So what I'm going to do is go ahead and let Mr. Wright. Mr. Wright, Mr. Poindexter's here. He's listed as counsel. What do you want to do in this case here?
Judge, it's our motion to revoke his probation. So long as Officer Garner is there in the courtroom prepared to testify, I would be prepared to call him as a witness unless there's a stipulation. But we're asking the court to revoke his probation.
Yeah, my understanding was he was going to stipulate on both cases. I may be wrong.
He stipulates on that. And you agree on both these cases, 21 CR 0068. Mr. Stockton, you're on that one. So he's stipulating on both of them. Is that correct?
That's what Ms. Costello told me.
Okay, now what have y'all talked to two prosecutors talked about a universal situation, or has he just got two different cases and we'll revoke him on both of them and let corrections take care of it?
That's my understanding. Be my recommendation.
Okay, that's what we'll do. Mr. Jones will revoke you on both cases and then they'll be in contact with you.
Your Honor, if the court would, he does wish to stipulate, but he wanted to explain to you why he left treatment because you had given him opportunity to go.
It's not necessary. I understand what happens at treatment. People leave. Some people don't make it. They got people there they don't like. They see drugs there. It's not a perfect world we live in. So I harbor no animus story anyway. Okay. Thank you very much.
Now, Judge, I haven't had very many revocations in front of you. Do I need to tender an order, or do you take care of the order in this case?
I guess just tender an order. Mr. Stockton?
Yes, Your Honor.
Why don't you,
We'll tender an order for
tender
Mr. Wright.
for both of you on different.
For both of them.
Yeah.
Very well. If I need to do anything else, somebody just let me know if I need to tender anything.
We will.
All right. Thank you, Judge. I
Okay,
believe
thank you.
that's all I have.
You're excused. Thank you.
Thank you.
Okay, let's go down through the docket in Adair County now. What have we got on the Monroe County case? Any reports of the fellow coming? Louis Arms. Commonwealth versus Louis Arms. Sentencing. Commonwealth versus Louis Arms, 21 CR 0058, 21 CR 0159, 21 CR 00137. Are you Louis Arms?
Yes, sir.
Born in 1964.
Yes, sir.
Last four digits, social security number 8381. You're here today for sentencing. If you had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Counselor, is it substantially correct after review?
I believe so, Your Honor. I
Any
didn't
reason
see
why
any
Mr.
corrections.
Arms should not be sentenced today?
No, Your Honor.
I'll plead guilty to burglary in third degree. Case number 21 CR 00137. He shall receive a sentence of 4 years. Going to plead guilty in 21 CR 0058. He shall receive a sentence of 3 years to 4 years and the 3-year sentences. The case shall run consecutively a total of 7 years, probated for 5 years, probation to be supervised. He shall be released today, shall receive credit for time served. And what's the court cost?
Both cases together is $480.
Both cases together is $480. I'll allow you to start paying that at $40 a month, starting 30 days from today. And I guess you're still going to enter the drug court. Is that
Yes,
right?
Your Honor.
Okay. Good luck to you, Louis.
Thank you.
Yeah.
Louis, you'll have to call Mr. Murphy to get the time that you're supposed to be here for orientation. Don't forget to do that.
I get out today.
Yeah.
All right, thank you.
No, Judge, he's got to be oriented for drug court.
No, they evidently you have to stay and get oriented for drug court. Has he been voted into drug court yet?
Yes.
So what you'll get out when you contact Mr. Murphy and he'll set up the day of orientation and then you get out. Shouldn't be very long. Okay.
All right, thank you.
Okay. How about Brandon Anderson? Have we done that? Brandon Anderson?
I'm bringing it back.
Commonwealth versus Brandon Anderson. Are you Brandon Anderson?
Yes, sir.
Born in 1994.
Yes.
Last four digits, social security number 1165.
Yes, sir.
You're here today for the purpose of arraignment. Mr. Coleman Hurd is here, appears to be representing you. Can you see him on camera there? Say something, Mr. Hurd.
Brandon, this is Coleman.
Okay, so it's voice activated. The grand jury of Cumberland County has returned an indictment charging you with trafficking a controlled substance first degree and endangering the welfare of a minor. Do you understand that?
Yes.
Mr. Hurd, do you acknowledge the identity of your client? Receive indictment, wait for him on reading.
Yes, sir.
And enter a plea of not guilty, reserving all pretrial motions.
Yes, sir.
Okay, what is Mr. Brandon Anderson's bond?
Judge, I think it's a $25,000 clerk approved surety bond.
And he can't make that?
I don't believe so, Judge.
That's a pretty reasonable bond.
He's working with some family members who might be able to work on it.
Okay, well, I'll do a review on that at some juncture if you get up with the Commonwealth.
I've reached out to Mr. Stockton, so we may
Okay.
be able to work something
Okay,
out.
he'll be here on the 22nd for negotiation. April 22nd for negotiation, and the 28th is the next court appearance, sir, and both those are conditions of your bond, okay?
Thank you, Judge.
Okay, Michael Birdwell. I'm signing signing order, reciprocal discovery order on Mr. Anderson. So get to him. Mr. Birdwell. Commonwealth of Kentucky versus Michael Birdwell, 21 CR 004, 22 CR 008. Are you Michael Birdwell?
Yes, sir.
What is your year of birth?
4/26/80.
Last four digits of social security number are 9859.
Yeah.
Okay. And we got some other microphone on here. Guess the regional jail microphone on needs to be turned off. I got some clatter in the background. Thank you. We're here today on these two cases, 004 and 008. What does the Commonwealth have to say?
Can we have another date, Your Honor? He has a case going to grand jury today too, if we can have a negotiation day.
Negotiation date on the 22nd
Yes.
of April, and next court appearance on the 28th. Your attorney will be in contact with you, Mr. President. Douglas Bowe. Commonwealth versus Douglas Bowe. Commonwealth versus Douglas Bowe, 22 CR 00102. Are you Douglas Bowe?
Yes.
Born in 1976.
Yes.
Last four digits, social security number 8789. Your attorney's present. Say something, Ms. Costello.
Hello, Mr. Bowe.
Okay, so, okay. We're here today on a pretrial conference. What do you have?
Your Honor, we're very close on a resolution if we could have one more settlement day.
Okay, a settlement negotiation on April 22nd. The next court date is on April the 28th. Your attorney says y'all are very close to reaching a resolution. If you do reach a resolution before then, I would consider scheduling an earlier date in one of the counties. Okay? Okay, your attorney will be in contact with you.
Okay.
Okay, thank you very much. Paul Bricker. Paul Bricker. Mr. Cross. Somebody find Mr. Cross?
What is it? Just say.
Commonwealth versus Paul Bricker, 21 CR 00148. Are you Paul Bricker?
Yes, sir.
Your year of birth is 1985.
Yes.
Last four digits, social security number 1839. You're here for a conference. What do you have to report, Mr. Cross?
Your Honor, I talked with Mr. Stockton. In meeting with Mr. Bricker, I'm going to have to attempt to locate some records from the state, from the Commonwealth of Virginia regarding whether or not there's any record of Mr. Bricker being.
The 22nd of April for another negotiation date and the 28th of April for the next court appearance.
I should have time.
Daniel Capolito. Daniel Capolito.
You just call my name. It ain't trouble.
Mr. Bricker, did you hear what was going on?
Yes, sir.
Okay, so they've got other documents, and so we set you a new negotiation date of the 22nd of next month and a court date for the 28th. They're getting some your attorney to get some documents from Virginia. Thanks to be your benefit, okay?
Yes, sir. Thank you.
Okay, thank you. Daniel Capilio.
Yeah, I'm here.
Okay, they need to turn the camera on. You're at the regional jail, right? Turn the camera on.
Good start. Okay.
There you are. The jail needs to turn the camera off and the regional needs to leave it on, okay? Are you Daniel Capilio?
Yes, sir.
Okay, are you born in 1971?
Yes, sir.
Last four digits, social security number 8954. This is a motion for shock probation.
Yes, sir.
Public advocacy do it or who did it?
I did, Your Honor.
Okay. Go ahead.
Your Honor, Mr. Capiello has an interesting case. He was originally on probation.
You're going to speak up so he can hear you.
Okay. He was originally on probation in 19 CR 08. He had was basically arrested for trafficking a controlled substance first degree. Department of Corrections decided to send him to a 6-month rehabilitation program. And so he went to CTS Russell in Louisville, Kentucky, completed that rehabilitation program and got out September 20th. He appeared in court here 3 days later and entered a guilty plea in this case, and then was immediately put into custody and then final sentenced in November 2nd, 2021. In the release paperwork from CTS Russell, it recommends he maintain sobriety for attending 4 documented substance abuse meetings, obtain stable
Well, if he
employment.
was sentenced that far back, can that be on the 180 days?
No, he was sentenced November 2nd. And that's the case that we're filing the shock probation in. And so basically our argument is, Your Honor, is that he completed the 6 months treatment the Department of Corrections recommended, and within 3 days of being released from that was incarcerated for the plea in this case. I believe that he hasn't had the opportunity to show the court that he can successfully be on probation and show.
What do you have to say, Mr. Stockton?
Your Honor, he was caught in Clinton County in 19 CR 8. He had 38 grams of meth in his possession. I believe he was passed out at the Best Western Motel. He took 6 years on that case. The Department of Corrections, in their infinite wisdom, put him in CTS Russell. While he was out, he got caught here in Cumberland County with 33 grams of meth. So he had over an ounce on him each time. And he entered a 10-year plea on that. So no, I'm not in favor of shock probating somebody that has had in a 3-year period over an ounce each in the meth in their possession in 2 different counties in my jurisdiction. I get all these letters that he's a great worker in Adair County. He probably could be, but he don't need to be down here in the 40th Judicial Circuit with all this methamphetamine on him on at least 2 different occasions.
What do you have to say, Mr. Whitaker?
Your Honor, I disagree with Mr. Stockton on that new case occurred before he went to CTS Russell. He spent 6 months in Louisville and never left Louisville.
Well, he was out on parole. He wasn't out on probation. He was out on parole when he committed the crime here in Cumberland County. So,
Okay.
Yeah, that may be the issue. I don't think we're misunderstanding each other. He was on parole, and then I guess corrections sent him to CTS Russell. But my point is, he was on parole on a 6-year sentence when he got the new 10-year sentence in Cumberland County.
It's just our argument, Your Honor, that he hasn't been given the opportunity to show that the 6-month rehabilitation was effective, that it worked. He was only out 3 days when he entered this plea, and he took responsibility for his actions.
How many days has he served on this? Is it a 10-year sentence, Mr. Stockton, he's got here?
Yeah, in Cumberland County is a 10-year sentence. Clinton County is a 6-year sentence.
The case that's before me now
is the 10-year Cumberland County case.
And did those actions that he was charged with in Cumberland County, happened before he entered a plea or before he was out on parole in the Clinton County case while he did the same.
That's correct. He had a 6-year sentence out of Clinton County that he'd been paroled on when he committed the actions in Cumberland County.
And then Department of Corrections were the ones that sent him to the 6-month rehab and not us.
That's correct.
Yes, sir. And the Department of Corrections has not revoked his parole. So I think that shows.
All I can say is he's well connected with the Department of Corrections.
I'll take it under consideration.
Thank you, Your Honor.
Nathan Costello. So he won't be available. He was transferred to the Kenton County Jail yesterday. So
Okay. Well, Your Honor, while we're here, I realize Mr. Castillo's had a lot of problems in Adair County, but I don't think we can do anything here until he is evaluated. And the more trouble he gets in, the clearer it is it needs to be done. So I don't think he could. Well, that's just all I wanted to say.
Well, we're going to try to. We'll try.
He's awaiting a KCPC evaluation, so
He's awaiting evaluation. So let's put him on next month again and see if they have it done by then, which if it's outpatient, they might. Put him on April the 28th. If it's not ready, then we'll take it to the next month. Claude Cole.
Your Honor, we are gonna have paperwork on that. It's complete. I just need to fax it over to the jail. I don't want to leave your docket hanging while I do
Are you
that.
Claude Cole?
Yes, sir, I am.
Claude, your attorney's sending some paperwork up there for you to review, and we'll come back to your case after you've had plenty of time to review it, okay?
Yes.
Okay. Keisha Crawford. Keisha Crawford. Commonwealth versus Keisha Crawford, 21 CR 00147. Are you Keisha Crawford?
I am.
You're here for sentencing. Have you had an opportunity to look at the pre-trial report, pre-sentence
Yes, I
report?
have.
Is it substantially correct?
Yes.
Okay, Counselor, your attorney's here. Say something, Counselor.
Hi, Keisha.
Hi.
Okay, is there any reason why this lady should not be sentenced?
No, Your Honor, we would ask the court to sentence her today. She was very anxious to prove to the court that she can do this.
On a plea of guilty to theft, unlawful taking over 10,000, she received a sentence of 5 years, probated for 5 years, supervised. She is received credit for time served. She should pay restitution of $1,900 through the Cumberland Circuit Clerk's office, $100 payment within 30 days, subject to the 5% fee for handling that. Jointly and severally with co-defendant Shannon Walters. Restitution will be dispersed according to the restitution order submitted in the plea. Both parties leaving your final restitution $500 currently held as bond should be applied, leaving a balance of $1,400. Court costs amount how much?
$185.
$185. I'll let you pay that at $30 a month since you're already paying the restitution. Okay? You understand?
Yes, sir.
Okay, I guess you'll need to meet with the probation parole officer when?
Be Monday, 8 a.m.
Monday at 8 a.m. You'd be in Columbia, Monday at 8 a.m. probation parole, okay?
Yes, sir.
Okay, thank you. Dale Cross, sentencing. Commonwealth versus Dale Cross. Are you Dale Cross?
Yes, sir, Your Honor.
Have you had an you're here for sentencing?
Yes, sir.
Is your year of birth 1958, Mr. Cross?
Yes, sir, Your Honor.
And last four digits, social security number 7749.
Yes, Your Honor.
Have you had an opportunity to review this pre-sentence investigation report with your attorney?
Yes, sir.
Okay, Mr. Poindexter, is it substantially correct?
It is, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon a plea of guilty of wanton endangerment, first degree, the defendant shall receive a sentence of 5 years, probated for 5 years, probation to be supervised, credit for time served, be released today, agrees to be assessed and follow recommendation with a social clinician. The court cost is how much?
This is $215.
$215. I'll allow you to pay that at $30 a month if you want to, or you can pay it all at once. Either one. Okay. You'll need to be with probation parole on Monday at 9 a.m.
Thank you, Your Honor.
Okay, thank you very much. Buddy Dyer. Buddy Dyer. Commonwealth versus Buddy Dyer. 21 CR 00135. Are you Buddy Dyer?
Yes, sir.
You're here today for a pretrial conference. You're represented by the Office of Public Advocacy. Ms. Costello. Ms. Costello, what do you have to say about Mr. Buddy Dyer?
Your Honor,
Who was born in 1987, right, Mr. Dyer?
Yes, sir.
And his last four figures of his social security number 6687. Go ahead.
Your Honor, I have sent the paperwork to the jail. It was sent with Mr. Cole, so
Mr. Dyer, they've sent paperwork up there for you to review. If you get it and review it, we'll call you back up in a few minutes, okay?
Okay.
Brandy Franklin. Brandy Franklin. Commonwealth versus Brandy Franklin. 21 CR 00119. You're here for sentencing, Ms. Franklin. Your attorney, Johnny Bell, is here. Have you looked at the pre-sentence investigation report out of probation parole? Have you reviewed the paper from probation parole, your pre-sentence investigation report?
No, Your Honor, I haven't got those yet.
Mr. Bell? Mr. Bell, your microphone is off.
I'm sorry, Your Honor. I have it here, Judge. I thought they'd send it to her. I apologize to the court, but I did not. I can fax it over if you want to call us back, Your Honor.
I've got a very tight docket today. I
Yes,
got 90 people on here and some hearings and everything. Well, okay, well, the problem is, if she's not sentenced today, you might not really care how much it costs Cumberland County, but it costs Cumberland County every day that she's not sentenced from today. Her jail costs, which probably $1,500. Now, I know you're from a rich county over there, but we're a relatively poor county here. So I expect you to get those to them when we have these sentences. So you get them up there and I'll try to get her in today, okay?
All right, Judge.
Raymond Garrett.
Your Honor, we're waiting on paperwork back from the jail. I sent it this morning.
Okay, do you meet with these people any before this thing? This waiting to do the paperwork today has got to stop. It's got to stop. This is like 4 or 5. I mean, I don't understand this.
Your Honor, I meet with them.
Tessa Gore.
I was contacted by Ms. Gore yesterday. I would, if there's any possibility of getting a continuance.
Based upon what?
basically, I'm not, just haven't really had a chance to talk.
Okay,
to my
issue a
client.
bench warrant and you'll know where to go meet her at.
Well, she's there.
Yeah.
She's in Dare County Jail.
Why? Well, she's here, so why we thought she
It's a
got,
revocation.
I know, but she's here, but
She's here
she's in jail.
in Dare County, right?
She's here. Look on the screen there. There she is.
Yes, yes, sir.
What do you want to do?
We will stipulate to the violations.
Are you Contessa Gore?
Yes,
What's your year of birth, Miss Gore?
96.
In the last four digits of your social security number, 0494.
Yes.
Stipulate to the probation revocation. Mr. Stockton,
Yes, Your Honor.
what do you desire to be done on this thing?
Well, I would just ask that the sentence be imposed if she stipulated, Your Honor.
Okay,
She evaded supervision and evaded arrest.
okay, well, I will revoke her probation. She can serve. Thank you very much.
Very well.
Dallas Hayes.
I'll say,
Yeah. There was a show cause on Contessa Gore's case for Matthew Hart to show cause today. Why he didn't appear last time. Is that right, Mr. Stockton?
I believe so. I was out the last motion day. So I believe there was though. I know she hired Mr. Soam.
Well, she had an attorney here. I'll just take advisement on Mr. D. Hart not being present today. Commonwealth versus Dallas Hayes. Are you Dallas Hayes? Born in 1990?
yes, sir.
Last four digits, social security number 8662.
Yes, sir.
You're here today for sentencing today. You understand that?
Yes, sir.
Have you had opportunity to review this pre-sentence investigation report by probation and parole? Have
Yes,
you?
sir. Yes,
Is it
sir.
substantially correct?
Yes.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty of possession of controlled substance, two counts, defendant should be sentenced to 1 year on each charge and run concurrently for 1 year. The court costs amount of what? $240. I'll allow you to start paying that when you're released at $30 a month, okay?
Yes, sir.
Okay, thank you very much.
Thank you.
Dustin Hayes. Dustin Hayes. Commonwealth versus Dustin Hayes, 21 CR 00138 and 22 CR 0005. Are you Dustin Hayes?
Yes, sir.
You born in 1986?
Yes, sir.
Last four digits, social security number 7836.
Yes, sir.
You're represented by the Office of Public Advocacy. Are both of these cases going to be resolved in this sentencing, or are they two separate cases?
They are two separate cases, Your Honor.
Mr. Stockton, you want me to proceed with the sentencing and then we'll talk about the pretrial on 0005? Your microphone's off, Mr. Stockton, microphone's off.
Yeah, I would like for him to be sentenced, start drug court, and if he gets his life in order, that other case may go away.
Okay. Well, I would just, okay, we're here on the sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole in 21 CR 00138? Mr. Hayes, have you seen this pre-sentence investigation report done by?
Yes, sir, I have.
Is it substantially correct?
The only thing that will need to be updated, Your Honor, is his jail credit because it was from last month and he's been held since then.
Okay. Take note of that. Is there any other reason why he shouldn't be sentenced today?
No, Your Honor.
On plead guilty to possession of controlled substance, defendant should see 3 years, pretrial diverted for 5 years. Was that pretrial diversion previously revoked?
Yes, it was voided, Your Honor, so he'll
Yeah.
be,
So it'd be 3 years to serve. Shall receive jail time, agree to be, follow the social services. I believe on this pretrial diversion, was this the one he was pretrial diverted and was found outside shortly after?
no, Your Honor, it was a couple of days later, he was found with methamphetamine in the new case. And that's why Mr. Stockton wishes to have him put into drug court so that he can try to get some help and get his life straightened out.
Okay, has he been voted in drug court?
Yes, Your Honor.
Okay, well, he'll stay until he gets the orientation date. And then we'll, on the other case, we'll continue the other case, 22 CR 005, continue it generally subject to redacted upon motion of Commonwealth. Okay. Mr. Murphy ought to be in contact with you pretty soon to see when your orientation can take place, okay?
I've already talked to Mr. Murphy.
Did he tell you what day the orientation would take place?
He said he was waiting on you, Your Honor.
Well, that's why I'm telling you, he'll be in contact with you.
Okay, I'm sorry. I apologize.
I understand, no problem. Okay, Emmett Lawrence. Emmett Lawrence. We just got about 8 more cases here and then we'll deal with this Monroe County thing. Emmett Lawrence, 20 CR 0049. Are you Emmett Lawrence?
Yes, sir.
Okay, were you born in 1987?
Yeah.
Last 4 digits, social security number 9969?
Yeah.
Okay. What do we have? We have a probation revocation. What do you have, Mr. Stockton?
Your Honor, Mr. Lawrence has a 3-year sentence on possession of a controlled substance first. He absconded drug court on November 18th of 21. And then when he was picked up and arrested, he was positive for meth. So I don't know if he wants to stipulate or not.
You want to stipulate?
I spoke to Mr. Lawrence yesterday, Your Honor. He does wish to stipulate.
Please stipulate. We will impose reinstate his sentence. His probation is revoked. Okay, thank you very much. Thank you, sir. Noah Neal.
Noah Neal.
Commonwealth versus Noah Neal, 21 CR 00143. Are you Noah Neal?
Yes, sir.
Okay. Were you born in 1998?
Yes, sir.
Last 4 digits, social security number 8621.
Yes, sir.
We're here on the diversion revocation. What do you have, Mr. Stockton?
Your Honor, he has a new felony arrest with methamphetamines, and I thought we might set this for April the 22nd, 28th, see if we can do a global settlement on it.
Okay, I have a PIN number entered on him. Okay. So the diversion. We can't do a PIN number on him on diversion, they say.
Okay. Well, we can proceed if you want to.
Yeah.
However you want to handle it.
You want to stipulate, then we will do away with it. We'll in the diversion, have a pre-sentence investigation report. And then on that day, if you can reach a global settlement, you can proceed with information and we can wrap them all up into one.
Yeah, he does stipulate that there was a new felony arrest, Your Honor.
Okay, well, or that he stipulate.
Just that there was an arrest, not to guilt as of yet. So I understand that will void his diversion by stipulating to a new felony.
Okay,
arrest.
so we'll see him negotiate on the 22nd of April, and the court date's on the 28th to try to wrap both of these up, Mr. Neal, okay?
Yes, sir.
Okay.
What
Michael Joe Nethery. Michael Joe Nethery.
Papers on him. Or they not think.
Wait.
Honor, I've spoken to the jail and they have sent the paperwork back. Mr. Nethery has 2 cases. We have an agreement on his new one and a stipulation on his revocation case.
Commonwealth versus Michael Joe Nethery, 19 CR 0068 and 22 CR 002. 19 CR 0068 is a probation revocation. I understand, Mr. Nethery, that you have agreed to stipulate and wrap your two cases up together. Is that right?
Yes, sir.
Okay. Well, I will revoke the probation in 19 CR 0068. In 22 CR 002, we have a plea. Is that correct?
Yes, it should be downstairs, Your Honor. I've spoken to the jail. They've sent it back. If I can run down there and grab it, but I didn't want to derail the docket any more than I
Could
had.
you have somebody in the clerk's office bring that up here real quick?
Their next case is Jamie Alderson, that's not, public access.
Okay, I want to go ahead. We'll come back to Michael Joe Nethery. Jimmy Otterson, Mr. Nethery, you just have a seat till they bring your papers back up here, okay?
All right.
Jimmy Otterson. Jimmy Otterson. Commonwealth versus Jimmy Otterson, 19 CR 0067. We have a pretrial conference. Mr. Otterson, you're there. Your attorney's Mr. Bates is here. Mr. Bates, will you just say something to keep the mic? Say anything.
Mr. Otterson, this is Eric Bates.
Okay, you see him there? Okay. Okay, what's the deal, Mr. Stockton?
We have a felony plea, Your Honor.
Okay. Mr. Otterson, what's your year of birth?
07/28/91,
And the last four digits of your social security number.
9087.
A motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
You're currently under the influence of drugs or alcohol.
I'm
Is
sorry.
this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 19 CR 0067?
Yes, sir.
Is your judgment impaired today?
I'm sorry.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? You believe you're fully informed about the case?
Yes, sir.
You realize that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. I'm going to read those rights to you and ask you to affirm that you're aware of them at the end. You have a right not to testify against yourself. No one can make you say anything. You have a right to be represented by counsel at each stage, including the jury trial. You have a right to confront and cross-examine a witness, call testify against you. You have a right to produce evidence, call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose and require a Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. Did you understand by entering this plea today, you give up all of those rights? Now I may consider the Commonwealth's recommendation, but I may apply any sentence within the range provided by law. I do not have to accept any recommendation. Prior to accepting the recommendation, I will wait to pre-sentence investigation, report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation? Mr. Alderson, listen to this closely, okay?
Yeah, 19 CR 67, the defendant will plead guilty to trafficking in a controlled substance first degree, receive a sentence of 5 years. He'll also plead guilty to DUI and receive a $200 fine and cost. He'll receive credit for time served. The Commonwealth opposes probation, shock probation. He will forfeit the $940 to Commonwealth. Agrees to have any and all drug paraphernalia and evidence destroyed.
Is that what you agreed to, sir?
Yes, sir.
Okay. Has anyone, including your attorney, offered you any other recommendation or benefit for the plea?
No, sir.
Pleading guilty because you are guilty? Is that correct? Okay, now, when you enter a plea to a felony, that could be used to enhance in the future under the persistent felony offender law. And on a DUI, if you get any future DUIs for a period, I think the law is now 10 years, but could be extended by the legislature as we've seen. that can be used to enhance additional DUIs. You understand that?
Yes, sir.
Okay, knowing these constitutional rights that you waived and knowing what I've told you about enhancement, is it still your desire to enter a guilty plea and let the court fix the punishment within the range permitted by law?
Yes, sir.
Okay. Is that your signature? Did you sign that document?
Yes, sir, it is.
Okay, and your attorney has it there, counselor, that is his signature?
Yes, it is.
Okay. Okay, well, I'll accept the agreement order pre-sentence investigation report and have you formally sentenced on the 28th. Mr. Bale, if you pick that up.
Judge, there's also included, I don't know if you have a copy of it, but an order of forfeiture for the $940.
Okay, I'll sign that too. Okay, you'll be, the probation parole officers will be up to see you, and then we'll have the sentencing on the 28th, okay? Thank you very much, counsel.
Thank you, Judge.
Yes, sir.
Jonathan Owens. Jonathan Owens. Combo versus Jonathan Owens. 17 CR 0014 for revocation, 20 CR 0009 for revocation, and 21 CR 00155 for pretrial conference. Are you Jonathan Owens?
Yes.
Born in 1990?
Yes.
Last four digits, social security number 8658.
Yes, sir.
Judge, we have a resolution, all three matters.
Okay, you have a plea?
We do, Judge.
A felony plea?
Yes, sir.
Mr. Owens, I understand that you've tendered a motion that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is the plea freely and voluntarily given?
Do what?
Is the plea freely and voluntarily given?
Yes.
Okay, so you're the same person named in indictment number 21 CR 00155.
Yes, sir.
Okay. Have you had opportunity to discuss this with your lawyer? Are you satisfied with his advice?
Yes.
You've reviewed all the evidence the Commonwealth has against you, and you feel like you're fully informed about the case.
Yes.
You have certain rights under the Kentucky and the United States Constitution. Before I can accept the plea, I need to go over these rights. At the end of them, I'm going to ask you if you understand them. You have a right to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter higher court if you lose, the right to acquire a Commonwealth on a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, you give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may accept but I am applying any range of sentence provided by law. I do not have to accept your recommendation. Prior to accepting the recommendation, I will wait the pre-sentence investigation report and probation parole. In the event that I do not accept the recommendation, decide to impose a harsher sentence, I'll give you an opportunity to withdraw your plea. Listen very carefully. Mr. Stockton, what is the recommendation?
Your Honor, Mr. Owens would plead guilty in 21 CR 155 to DUI, fourth offense, and get a sentence of 1 year to serve. That 1 year sentence would run consecutively to 20 CR 9 and 17 CR 14. He would stipulate to the revocation in those two cases.
Okay, I'll revoke those two then, 17 CR 0014, 20 CR.
That'd make a total sentence of 11 years. He'd get credit for time served. The Commonwealth will oppose probation or shock probation, and all evidence in this case be destroyed.
Is that what you agree to, sir?
Yes.
Okay, you're pleading guilty because you are guilty and for no other reason?
Yes.
And knowing your constitutional rights, so explains that still your desire to give up these rights, enter a plea of guilty to the charges and allow the court to fix your punishment. You understand that after sentencing, this conviction along with others could be used to enhance the penalty range in the other felonies. You understand that?
Yeah.
Counselor, you recognize on the document your client's signature?
I do, Judge.
Okay, now he hasn't been a state prisoner I don't guess, so we'll have to do a pre-sentence investigation for, and you'll be back here on, you'll be back here on April the 28th for sentencing, okay?
Judge, I have 2 revocation orders to tender for.
Okay, the next is Gene Parrish for sentencing. Commonwealth versus Gene Parrish, 19 CR 0040. Are you Gene Parrish?
Sir.
Okay, have you had an opportunity to look at the pre-sentence investigation report under probation and parole?
Yes, sir.
Is it substantially correct?
Yes, Your Honor.
Is there any corrections need to be made?
I did not see any corrections
Okay,
unless,
his diversion was revoked on February 24th, 22. So he's reviewed it. There's no reason not to sentence him upon plea of guilty possession of controlled substance. He shall receive 3 years.
Your Honor, we would ask the court to consider allowing Mr. Parrish to attend a long-term treatment program.
What happened to him in the specialty court?
Your Honor, was not able to complete that. He was terminated not for non-compliance. He was terminated from drug court for medication issues. And then he was on probation and had new violations while on probation. Continued drug use.
I'm just gonna sentence him and they can work it out. So I'll sentence him to 3 years. And what are the court costs in this case?
He just owes $20. He's paid.
You paid most of it, just owes $20, so pay the $20 within 30 days after you get released. Okay, thank you very much. Bernice Stearns. Bernice Stearns for sentencing. Are you Bernice Stearns?
Yes, sir.
This is 19 CR 00106. You born in 1982, Ms. Stearns?
Yes, sir.
Last 4 digits, social security number 0513.
Yes, sir.
Okay, you're here today for the purpose of sentencing. Have you reviewed the pre-sentence investigation report on the probation parole?
Yes, sir.
Counselor, is any reason this lady should not be sentenced today?
Your Honor, we would ask the court to consider referring her to drug court in lieu of serving her sentence.
What do you say, Mr. Stockton?
I might agree to it if on shock, if she's eligible. She altered a drug screen is the reason she was revoked. So I think she should serve a little time.
Okay. Yeah, I'm going to go ahead and sentence you to 2.5 years. Each charge run consecutively for 5 years. What are the court costs in this case?
Still owes 170.
Still owes 170. So when you get out, you need to pay the 170 at starting at $40 a month, 30 days after you're released. Okay, thank you very much. Shannon Walters. Shannon Walters. 21 CR 0062, 21 CR 00146. Are you Shannon Walters?
Yes, Your Honor.
Okay, you're here, you were born in 1978, is that correct?
Yes, Your Honor.
Last four digits of your social security number is 8119. You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done on probation and parole?
Yes, Your Honor.
Okay, Counselor, you're represented by DPA.
Yes, Your Honor.
Is everything in here substantially correct?
Yes, Your Honor.
The reason he shouldn't be sentenced?
No, Your Honor.
Upon a plea of guilty under indictment number 21 CR 00146, he shall receive 6 years. Shall receive credit as appropriate. Restitution as indicated original order. And court costs from
For both cases, it's $425.
$425. I'm going to combine them. Combine the costs and the two of them, save you a couple $100.
Thank you, Your Honor.
And you can start paying it at $40 a month, 30 days after you're released.
Your Honor, it was a probated offer.
Was it a probated offer, Mr. Stockton?
Yes, Your Honor.
Okay. You need to report to the probation and parole officer at 11 o'clock on Monday. Is that right?
10 a.m.
10, well, you get to go an hour early, so you have to get up a little earlier. 10, okay. Jimmy Webb. Says Robert Stevens represents him.
He had a conflict contractor, Your Honor, and then Mr. Poindexter took the revocation case.
And I believe that we were trying to work out an agreement with Mr. Stockton on this.
Let me call it, let's see, okay. Commonwealth of Kentucky versus Jimmy Webb, 22 CR 0012, 21 CR 0067, and 19 CR 0023. What do you have, Mr. Stockton?
Yeah, there's a motion to revoke in a new case. I wanted to make sure there was a pin on it, Mr. Webb. Mr. Poindexter and I have been in discussions. There's some things going on behind the scenes that we've not had any control over as far as time limits. Could we have another pretrial and a negotiation date?
Negotiation day on the 22nd. The next pretrial on or hearing on this case is on April the 28th.
Yes, sir.
That would be on all three of those cases. Okay, thank you very much. Jerry Winningham. Jerry Winningham. Jerry Winningham. Commonwealth versus Jerry Winningham, 21 CR 0096. Are you Jerry Winningham?
Yes, sir.
Born in 1975.
Yes, sir.
Last four digits, social security number 8344.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to read the pre-sentence investigation report on the probation and parole?
It was, sir.
Have you reviewed the pre-sentence investigation report done by probation and parole?
Yes, sir.
Okay, is it substantially correct, counselor?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty possession of controlled substance, the defendant shall receive a sentence of 3 years. On a plea of guilty with tampering of physical evidence, receive a sentence of 5 years. Failure to maintain insurance, defendant should pay a $500 fine. 3-year and 5-year sentence shall run concurrently for a total of 5, serve 120 days. The balance probation for 5 years supervised, receive credit for jail time. Court costs in the amount of what?
$720.
Does that include the $500 fine? Okay, $220 court costs, a $500 fine, total $720. I will allow you to pay that at $50 a month, starting 30 days after your release. You shall remain on active probation until the restitution and fines are paid in full. When should you come to meet you?
Monday, 11 a.m.
What time?
11 a.m. on Monday, Your Honor.
Coming at 11 a.m. to Columbia at the probation parole office, okay?
At ma'am.
11 a.m.
Okay.
Probation parole. Okay.
Your Honor, he has a 120-day alternative sentence. He served 88 of those days.
Okay,
If the-
so I guess you'll need to see him at the jail.
Oh, it's 88, yes.
Timothy Ray. Timothy Ray. Timothy Ray. Commonwealth versus Timothy Ray, 21 CR 0041. Are you Timothy Ray?
Yes, sir.
Okay, you're here today for a pretrial conference. You're represented by the Department of Public Advocacy. Were you born, what year were you born?
99.
99, okay, and last four digits, your social security number.
3132.
Okay. Mr. Stockton, what do we have worked out here? Need to put your microphone on.
Yeah, it's a felony plea with time to serve.
Okay. Mr. Ray, I've been informed that you tendered a motion that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Okay. Are you the same person named in indictment number 21 CR 00141?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
We have plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, and do you think you've been fully informed about your case?
Yes.
You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to a higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt all the charges against you. Understand that?
Yes, sir.
Okay. By entering a plea here today, you give up those rights. I may consider the Commonwealth's recommendation, but I may apply any sentence, any range of sentence provided by law. I do not have to accept it. Prior to accepting the recommendation, I will wait for pre-sentence investigation report to be done with probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence on you, you have a right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, Mr. Ray will plead guilty to theft by unlawful taking over $10,000 and receive a sentence of 5 years to serve. That 5-year sentence shall be run consecutively with the Dire Circuit Court indictment number 21 CR 141. All evidence in this case be destroyed.
Is that your understanding of the Commonwealth's recommendation, sir?
Yes, sir.
Okay. Are you entering this guilty plea because you are guilty? And for
Yes.
other reasons? Knowing your constitutional rights, I've explained to you, you wish to waive them and to allow me to sentence you within the range permitted by law.
Yes.
Okay, you understand if you enter this guilty plea as well as your other felony convictions, they can be used against you to enhance penalties in the future.
Yes.
Counselor, is that your signature? Your client's signature on there?
Yes, Your Honor.
I'll accept the agreement order pre-sentence investigation report and have sentencing on April the 28th. Okay? Thank you very much.
Thank you.
Okay, now let's do a cleanup here of the few cases that we had to pass over. I guess we had Claude Cole. Do we have anything on? Which ones? I'm going to let public advocacy bring up the ones that you need to bring up. Mr. Bell,
Yes, Your Honor.
Have you got your information over to your client?
We have. We had previously sent that, Judge. I don't know what took place during that situation, but anyway, We take blame for it. We apologize to the court. I would like to advise the court, Your Honor, that Glasgow was the 8th poorest city in the Commonwealth of Kentucky, contrary to us being a rich area over here. We are not, Your Honor.
Well, you just don't, you live on Silk Stocking Street yourself, so you just don't understand what everybody else is going to. But I'll take note of that, and I tell you what we might have done here, Mr. Bell. We might have a benefit for Glasgow here in Burkesville now that you're on such hard times over there, and we'll sell some cakes and pies.
The fact that NFC, they think they.
Any help that y'all could give us, Judge, would be greatly appreciated.
Mr. Hunley said that they might be poor, but they have the air, appearance, and belief that they're wealthy. So that.
Well, there is some what I call $2 millionaires over here. I'll agree with that, Judge, but I don't like them no more than anybody else.
Well, I love them. I love them to come to the lake over here and spend their money on us depressed areas. Now, what's your client's name again?
Brandy Franklin, Your Honor. We're
Okay.
here for sentencing.
Okay,
I would ask the court
Brandy
to withdraw the
Franklin.
plea.
Commonwealth versus Brandy Franklin, 21 CR 0019, here for sentencing. Ms. Franklin, now have you had an opportunity to review this pre-sentence investigation report now?
Yes, Your Honor.
It's substantially correct?
Yes, Your Honor.
Okay. Upon plea of guilty possession of controlled substance, the defendant shall receive a sentence of 3 years, and she shall receive credit for time served. What's the court cost?
She's paid her court.
Court costs are already paid. Okay. Okay, thank you very much.
Judge, is she sentenced or is we following the plea agreement on the diversion and the rehabilitative measures that we agreed upon?
Mr. Stockton?
I thought she was revoked. I didn't think there was any plea agreement still in effect.
My understanding was her bond was revoked, but we hadn't been
No, her
sentenced.
diversion was revoked. And this is a pre-sentence investigation report that you do after a diversion is revoked to prepare for sentencing. Today,
Yes.
we're here for sentencing. So she stipulated on those other things and now we're sentencing.
I would ask the court to consider, Your Honor, due to the fact I know that she made some terrible mistakes. And I know she done some wrong things, Judge, and I'd be the first one to state that. But as I discussed with Mr. Stockton during the negotiation day, Judge, it's hard to deal with someone that's high. And I believe that Ms. Franklin was high, wasn't in the right state of mind. And I would ask the court to please consider at least allowing her an opportunity to get some help with this issue she's been dealing with basically.
There are places that she can get help where she's going, and she's also eligible for motion of shock probation, isn't she?
Yes, sir.
So let's see what she can get where she's going, and you talk to Mr. Stockton, and we'll consider what y'all can put together when we consider a shock probation. Okay.
Thank you, Judge.
Okay. Okay. Do we have Claude Cole?
Your Honor, the documents came back unsigned. They're resending them, but we do have Michael Nethery completed.
Michael Nethery. Commonwealth versus Michael Nethery. And is this the last one besides Mr. Cole?
I think Raymond Garrett too, Your Honor.
We have Garrett, Dyer, and Cole.
Commonwealth versus Michael Joe Nethery. (19 CR 0068 and 22 CR 002. Did we already revoke on 19 CR 0068 by stipulation?
Yes, Your Honor.
Okay, so now we're here for a plea on 22 CR 002.
Yes, Your Honor.
Okay. It's a felony plea.
Yes, Your Honor.
A motion has been tendered, sir, that says you wish to enter a guilty plea today. Is that correct?
Yes.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in these two indictments that I just announced?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with your advice?
Yes, sir.
Reviewed all the evidence the Commonwealth has against you.
Yes.
Feel like you're fully informed about the case.
Yes, sir.
Okay, you have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented counsel, jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, have process issued to appeal or attendance, the right to appeal this matter at higher court if you lose, and right to acquire the Commonwealth on a reasonable doubt that you're guilty charged against you. You understand that by entering a plea of guilty, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I do not have to accept any recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation reports done with probation parole. In the event that I do not accept the recommendation, decide to impose a harsher sentence as allowed under the law, you can withdraw your plea. What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, in case number 22 CR2, Mr. Nethery will plead guilty to failure to maintain insurance on a motor vehicle, receive a $500 fine. He'll also plead guilty to possession of controlled substance first degree, receive a sentence of 1 year. That will run consecutively with Cumberland indictment number 19 CR 68. He will stipulate to the revocation in that case. He'll pay court costs at the discretion of the court, receive credit for time served, and all evidence in the other case be destroyed.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you are guilty and doing it voluntarily?
Yes, sir.
Okay, knowing your constitutional rights, it explains to your desire to allow me to sentence you within the range permitted by law.
Yes, sir.
Do you understand that this conviction and the one that you've been revoked on can be used in the future under persistent felony offender law?
Yes, sir.
Okay, now, Counselor, have you seen his signature there on the document?
Yes, Your Honor.
Is that indeed your client's signature?
Yes, Your Honor.
Okay, well, I'll accept the agreement with the pre-sentence investigation report on the probation roll scheduled for April 28th. Okay? Thank you very much. Now, who we got left on this docket?
We have Garrett, Dyer, and Cole, Your Honor, and I'm waiting for the signed documents. Part of them came back.
You don't have them on any of them?
We have portions of
You don't
them.
have them on any of them? You're not ready on any of them? is what I'm
No, Your
asking. Okay, so let's proceed to any other matter we have on the criminal docket. Are we ready in the Monroe County case to proceed?
Yes, sir.
Okay. Adair County, we'll have to keep you on the line till those documents get resent, but we'll call you back up as soon as we can. Monroe Circuit Court, bring Mr. Strode out. We need to turn the camera off at the Adair County Jail. Thank you. Mr. Poindexter, you clean yourself a place off there. I know the public.
I'm fine right here. If you don't have to do anything else.
Your client can-
Just blocking you.
No,
I can just stick it in this bucket.
I'm gonna sit right here and he can sit right here next to me.
Okay, this is a continuation of a suppression hearing in Monroe Circuit Court case number 21 CR 00113. Was it yesterday or the day before we had it?
Tuesday.
Tuesday. I mean, all these days are running together. So in any event, there were some additional witnesses that the Commonwealth desired to call. You have a witness you'd like to call?
Yes, Your Honor, I'd like to call David Graves.
Mr. David Graves. Mr. Graves, this is a witness. I get mixed up with this is where you sit over here. In Monroe County, it's to the right, and I was already pointing you over this way. Would you raise your right hand? You swear testimony about you is the truth, whole truth, nothing but the truth.
Yes, sir.
You can sit down there and you can lower your mask there since you're behind those shields. State your full name for the record, please.
Sir.
State your full name for the record.
Okay, David E. Graves.
Okay, you can lower your mask with the hearing stuff. Mr. Bailiff, will you take the hearing over there, James? 1, 2, 3, 4. Is it working? How about that, Mr. Graves? Is that better? Can you hear it better now? Is that working for you? How about that?
Yeah, it's better.
Okay, okay. You state your full name, please.
David E. Graves.
Okay, and where's your residence?
Sure.
Don't give an address, just what town or whatever.
Okay. 96 Leisure Lane, Scottsville, Kentucky.
Okay. You may answer the questions. You want to move up here? And speak up really, really loud. And you can drop your mask if you'd like to too. I'll put mine on.
Can you hear me, Mr. Graves?
No, I can't.
You're gonna have to speak up now.
Can you hear me? Okay.
I can't now.
Okay, you can. Okay. Are you familiar with Terry Strode?
Yes, ma'am.
Is that Mr. Strode seated at the defense table with his attorney?
It looks like him.
How do you know Mr. Strode?
I've known him through the years.
Speak up. What did you say?
I said I've known him all through the years.
Okay. And do you recall March the 17th of 2021?
Yes, ma'am.
Okay. Could you tell the court about that day?
The night prior, I had received a message about my vehicle that had been missing.
What kind of vehicle was missing?
It was a Mustang, 2008 427R Mustang.
Okay. What did the message say?
I was advised that they thought they had seen my vehicle in the Heston community. And further with that, I asked him how long he had been there, and I think he said a month, maybe 2 months. Then after I got off the work, because I was working at the time, after I got off work that morning, I proceeded over there and located my vehicle.
Okay. What time did you get off work?
It was around 0500, someone's in there,
Okay.
4 o'clock in the morning, 4:30, something like that.
And were you given a location of where your vehicle was?
Yes,
Okay. What was that location?
Mr. Strode's residence.
Okay. Were you familiar where Mr. Strode lived?
Yes, ma'am.
Okay. And when did your vehicle go missing?
Probably around 2 months prior to that, it had broken down and I had left it at a residence there, but that was okay with it. And when I went to pick it up, it was missing.
Where was that? Where was the residence at that you'd left your vehicle?
I don't know the correct address, but it's about 9 miles northwest of Tompkinsville.
Okay.
That's the,
Whose residence was that?
I think it's Mr. Allen Gross's.
Okay.
At the time.
When did you realize your vehicle was missing?
Right around middle of February, somewhere's in there,
Okay. And how did you find out that your vehicle was missing?
because I went to pick it up.
Was Mr. Gross there at his residence?
No, ma'am.
Okay. Did you have any conversation with Mr. Gross about the whereabouts of your vehicle?
No, ma'am.
What did you do after that point, trying to find your vehicle?
I tried to ask some questions, but there was a very few people that I could ask or trust or whatever, afraid that the vehicle would be, either be stripped or sold. So I just tried to locate it on my own.
So you never reported it stolen to the sheriff's office?
No, ma'am.
So on March the 17th, you said you went to Terry Strode's house?
Yes.
Okay. What did you do once you got there?
Once I arrived at his residence, I observed my vehicle in the backyard.
Where could you see your vehicle when you were traveling on the road?
The front end would be, facing south, so I could see the front end of the vehicle, which clearly was mine. And I also made like 4 trips back and forth just to make sure.
At that point, what did you do?
Then I went down the road and I I called the sheriff's department.
How did you know it was your vehicle?
It's a rare vehicle. I mean,
How is it rare?
there's only 100 of them made, only 20 of them that color, and only 5 convertible.
And what color is it?
It's a grabber orange.
Okay, where did you purchase this vehicle from?
Had it ordered out of Owensboro, Kentucky.
Okay, and give me some details about the vehicle.
That's a Roush Mustang for one. It's grabber orange, black, convertible. I mean, it's the only one I've seen, period.
How did you said you contacted the sheriff's office after that?
Yes, ma'am.
How long before the sheriff's office arrived or someone from the sheriff's office arrived?
Probably 20, 25 minutes.
And
something like that.
who arrived on scene?
Yes.
Who arrived on scene from the sheriff's office?
Sheriff Ford.
And what happened after that?
Well, I stayed back until he called me, to come there. We didn't want no confrontation.
Could you speak up a little?
I said he tried to make contact with the residents, and there wasn't anyone there.
Where were you at whenever he made contact with the
I was
residents?
waiting down the road about a quarter of a mile,
Okay,
waiting on his phone call.
okay. So he called you. What happened after that?
Well, I proceeded to the residence, and the sheriff was in the back, and I walked around there with him, and he asked me if that was my car. I said, yes, that's my car. And I think he, of course, my tags on the car was, FOP tags, which federal, fraternal order of police.
And what's special about that?
It's fraternal order of police. You don't see many of them. So I think he then called the sheriff's department. And ran
Speak up
the VIN
just a
number.
little bit if you can, okay?
Okay, sir. I said, then I think he called the sheriff's department. And
Who was
then
that?
Sheriff Ford,
Okay.
and ran the VIN number. And then the VIN number come back to me.
Where was the VIN number located?
It's on a dash.
Okay. Did you see it
Yes,
from standing outside the vehicle?
yes, ma'am.
How long did it take for someone else from the sheriff's office to arrive?
Oh. Probably maybe 25, 30 minutes.
What did you do in the meantime?
I just stepped back.
Okay. After who arrived then on scene?
I really can't remember which one arrived first. There was 2 more came.
What happened to your vehicle after the sheriff's office was there?
It was towed.
Okay, who had it towed?
Eddie Hammer's service. I had hired him to tow my vehicle.
So you hired a tow company to come and get the vehicle?
Yes, ma'am.
Okay, where's the vehicle now?
It's at 96 Leisure Lane.
Do you still, so
Scottsdale.
you still have the vehicle?
Yes.
Do you know of any reason as to why Mr. Strode would have your vehicle or would have had your vehicle at that time?
No, ma'am.
Did you still have the title to the vehicle in your possession on
Yes.
March the 17th of 2021?
Yes.
Where was the key to that vehicle on that day?
I have no idea where the key's at. There was a key in the vehicle, but it wasn't the key that went to the vehicle.
Anything else? That's all I have for this witness.
You like to inquire? Just briefly, Your Honor.
Mr. Graves, when you saw this orange Mustang in the backyard of Mr. Strode's house,
You can drop your mask too while you question.
when you saw that orange Mustang behind his house, you didn't go up to that Mustang by yourself, did you?
No, sir.
Okay, you waited until the sheriff got there, right?
That's correct.
And the sheriff got there actually before you, because you said that he called you to come down to that scene, right?
Right.
And so the sheriff is the one who went around back and checked the VIN number on the car, right?
That's right.
That's all I have. Thank you.
You have any other questions?
Not for this
Do we
witness.
have a trial schedule?
Yes, sir. April 19th. April 19th.
I wasn't aware of one.
Okay, while you're here, I just want to recognize you for your attendance to April 19th in the trial of this case. Just raise your right hand. You recognize in a penal sum of $500 that you will appear to testify in this case on April 19th to be present at 9 a.m. at the Monroe County Justice Center.
Yes, sir.
Thank you very much. Now, may this gentleman be excused and go about his business?
Yes, Your Honor.
Okay, you may be excused. Thank you for coming here. Okay, you have another witness you want to call?
I call Sheriff Dale Ford.
Okay, Sheriff, you want to take a stand over here? You raise your right hand. You swear a testimony about to give the truth, the whole truth, nothing but the truth, except you got it.
I do.
Okay, take a seat there. You may lower your mask and tell us your name, what position you hold.
Dale Ford, Monroe County Sheriff.
Okay, you may inquire.
Are you familiar with the case of Commonwealth of Kentucky versus Terry Strode?
I am.
Is that Mr. Strode seated at the defense
It
table
is.
with his attorney? Do you recall the events that took place on March the 17th, 2021?
I do.
And how did you get involved in this case that day?
David Graves called me as early that morning, around 8 o'clock or so, and said that he had found his car that had been stolen. And he told me it was at Terry Strode residence.
Okay. Prior to that day, did you have any familiarity with his vehicle, with Mr. Graves's vehicle?
Yes, I know David's vehicle. I've known David since he was a teenager.
And what did you know about the vehicle?
It was an orange Mustang convertible, really nice car.
Okay. Was it unique to you?
It was. You don't see many of them.
Were you also familiar with where Mr. Strode lived?
Oh, yes.
Okay. And how far from the city limits of Tompkinsville did Mr. Strode live?
I'm gonna say approximately 6 miles, maybe.
When you arrived to Mr. Strode's house, could you see the vehicle in question?
I could.
Okay. At what angle could you see the vehicle?
Well, there's a tree line just before you get to his house, and you could see the car sitting behind the house.
Did you immediately recognize the vehicle?
I did.
And after you arrived there, what did you do then?
I pulled in there, walked around behind the house, looked at the vehicle, and I called David to come there to verify that was his vehicle. I saw the FOP tags, which was another clue I had. And when he got there, we ran the serial number and it came back to David Graves.
Did you try to make contact with anybody at the residence?
I knocked on the door, but nobody was there.
And did you have to cross any barrier to get to the backyard?
No.
Where was Mr. Graves's car located in relation to the house?
He was sitting behind the house, maybe 15 feet from the back of the house.
Where was the driveway of this residence located? If you're facing the house, where's the driveway?
It goes to the left side of the house.
Was there anything in that driveway?
Yes, there was a car there.
Okay. Was there anything else in the front of the house?
There's a lot of stuff laying around there, yeah.
Give me some descriptions of what was in the
Car
house.
parts, just stuff like that.
In the backyard, what was located in the backyard of the house?
There was, I think there was an old lawnmower sitting near the house.
You say near the house, where was it in relation to?
It was sitting like maybe the center of the house, up close to the house, the lawnmower.
Was there any outbuildings in the backyard?
Seemed like there was maybe a small building over the hill there.
Okay. Was there a fence around the home?
There was a farm fence back there in the back, I think.
Describe the fence. What type of fence was it?
I'm wanting to think barbed wire,
And how far was it from the house?
probably 50, 60 feet, maybe,
Okay. What was beyond that fence?
pasture.
Was it Mr. Strode's real property?
I don't think so.
There
There was another car sitting back there also.
behind the fence or near?
It was sitting to the, if you were facing the rear of the car, it was to the left, but back where you could see it from the driveway.
How many vehicles total were on this property?
Oh, down over the hill, there's probably half a dozen or so.
Approximately how many acres does this house sit on?
maybe an acre and a half. I'm not sure. I'm not good at that.
Okay. How long had you, how long did it take you to get to the scene after Mr. Graves had contacted you?
10, 15 minutes.
When, what happened after you ran, or that you all ran the VIN number on the vehicle?
On that VIN number,
Uh-huh.
we run that VIN number and I called for a rollback.
You called for a rollback?
Mr. Graves asked me to call for a rollback to get his vehicle. And I called, I believe it was Eddie Hammer come and got it.
And who arrived after you called the rollback?
Well, I had my deputy on the way. I had two deputies, actually, Tyler Shaw and David Lunds. And I turned the case over to David at that time.
Did you leave the scene after that?
No, I stayed around a while.
What questions I have, Your Honor?
Mr. Poindexter?
Sheriff, the backyard behind that house, about the same size as this courtroom, isn't it?
The house?
The backyard of it, between the house and the fence.
Could be, yeah. I didn't tip it off.
Right. And there was a fence went around three sides of it, and then there was a road in front of it, correct?
I think that's correct, yeah.
Of the
I think
yard?
the fence went around the background, yeah.
Okay. And all three of the stolen cars were inside that fence, correct?
Correct.
And you could not read the VIN numbers of those three vehicles from the road, could you?
No.
Okay. No other questions, Your Honor?
You have anything else?
No, Your Honor.
Okay, this witness be excused.
Yes, Your Honor.
Would you like to be heard, Mr. Poindexter?
I would, Your Honor. Your Honor, we've heard quite a bit of testimony about the uniqueness of this vehicle. And it's ironic that the first page of the United States Supreme Court opinion in that Collins case specifically describes the motorcycle they were looking for as being an orange and black motorcycle with an extended frame. And I believe somewhere else in here, it describes it as being unique. One of the differences in the case is that that motorcycle was in the driveway in front of the house. Here, we've got a Mustang and two other stolen vehicles in the backyard of the house, behind the house. The sheriff testified that he could not read the VIN numbers from the road. We've got testimony now that David Graves never approached the vehicle before the sheriff got there. And that in fact, it was the sheriff who went around behind the house to check the VIN number. So I believe it clearly falls within this Collins versus Virginia case and that the evidence should be suppressed. I don't know of any other argument that I need to make on that.
Okay. Who shall be heard for the Commonwealth? Very, very clear, Your Honor. Now, don't make any promises you can't keep.
That's a subjective mistake. Well, Judge, the main difference in the two cases is A, the motorcycle was covered by a tarp, the officer, and it wasn't an officer that went in. It wasn't a private individual. It wasn't the owner. The officer had to remove the tarp and take a look at the vehicle. And then he had to further investigate. So that's a major difference between what happened here. In this case, and I didn't know it until Mr. Graves testified today exactly how unique that automobile was. A Ford, an orange Ford Mustang convertible that there were only 5 of that color and model made in the world.
This is almost as good as Cousin Vinny, isn't it?
It is. I mean, that car was unique. And when Mr. Graves received a tip where it was, he knew where to look and he could see it from the road. And the minute he spotted that, he knew without any VIN number or anything else, that's my car. Now, that alone, if that's not a search, but it's a view, and I would just ask the court, what is he supposed to do when he discovers that his car, which I could describe right now as a collector's item, and I notice he still has it. What is he supposed to do? Can he just go in and hook it up and drag it off? I guess he could, but that could have caused trouble with Mr. Strode. Now, he did what I think any citizen would do. He called the law. And when the law got within sight, Officer Ford has known Mr. Graves since he was a teenager. He has known that car because it was bought, it was a custom-made car. And it was an unusual car to be found in the Heston-Mernon area of Monroe County. This wasn't just a car lot out here full of cars, all of them black and some silver. It was a bright orange and it was unique in a variety of ways. So it's the Commonwealth's position that once he described that, once he knew that his stolen car had been found, that the officer had probable cause to enter into that and make an investigation. Now, the Commonwealth would dispute that this car was within the curtilage of that house. It's my understanding of the law that the curtilage of the house is the area immediately surrounding the house that is usable by that person for the purposes and the promotion of residing in the residency therein. This place, according to the testimony here, was at least 6 old used cars around the house and including in the front yard. And Mr. Lutz's testimony, I believe, said there was 8 used cars there. So the question is, was that the curtilage of a house or was it a junkyard? So the issue of curtilage in this case, I don't believe would be applicable in that Collins case.
You're saying curtilage is defined by what you need around the house to occupy the house.
Yes, and to
And that
use
you don't
the
need
house.
8 cars around it to occupy the house.
Absolutely
So
not.
including the curtilage. Is that what you're saying?
I'm saying that the curtilage in this circumstance
Yeah.
doesn't extend beyond the use. So the curtilage issue is not what would control here.
Okay. Let me ask you a question. This owner, Mr. Graves, got a tip, went over and recognized his car, knew it was his car. You can establish that the car was there with the fact that he went over there and saw the car and got the car and removed it. So really, the sheriff's testimony about the VIN number is not crucial.
No,
to the case.
That's my point.
Yeah, and the other thing about it is the VIN number could be easily obtained now by Mr. Graves since he has a possession of the same car that he removed. He could say that was his car and he knows the VIN number. He could look at it now. There is a line of cases that talk about the inevitability of discovery.
You know, that would be applicable, of
Yeah.
course.
Yeah,
Inevitable
and
discovery.
you know, that as I look at this case, if this man knows his car, it's a special car, it's a rare car, he goes away, he calls the police so he won't get into armed confrontation and problem with the landowner. He gets over there, even though the officer is there, he gets the vehicle, understands the vehicle is his, and he removes the vehicle, got the vehicle. I think it was inevitable once he found the vehicle that the VIN number would be discovered. So I don't think if that's the only thing that was there. And he had the plate there that was the special plate that he put on it that the owner saw. So I'm going to rule that I'm going to rule that certain evidence, such as the VIN number that the officer got at the time, will be excluded. In other words, the fact that he got the VIN number there and he cannot say that he could identify that vehicle as belonging to the defendant. And then the defendant.
Well, he couldn't use the VIN number, but
Well,
he personally knew.
Unless he personally knew that.
That was his testimony.
Well, if he personally knew, but I'm saw him by the VIN number, he can't say that he knew that it was a defendant. The other thing is his encroachment onto the property, even with a defendant, might preclude him from being able to testify at all that he knew it was the defendant. The owner of the vehicle can sufficiently provide that information for the trial. The officer can be with him and that sort of thing and say what he saw, but not the VIN number and not any investigation he did at this time. That's what my ruling is going to be.
Well, of course, there are other aspects of the case, Judge.
I understand, and he can testify about that. Testify that he got a call from this person. He responded.
Well, and they interviewed Mr. Strode after that.
Absolutely. Absolutely. So I don't think those are the fruit of the poisonous tree or anything, because he had information sufficient to go question Mr. Strode when the vehicle was identified by the owner on the property and was in plain view. So that's what my ruling, if you could reduce that and submit a ruling on it to that extent.
All right. Thank you.
Now, we have a trial date that's set, and the witness has been recognized to be there on that date. Are there anything else for you, Mr. Poindexter? You preserved this objection very well for the record. You've got testimony. Is there any other things while we're here to talk about this case?
Your Honor, just that I'll have to talk to my client, and I want to see the findings of facts, conclusions of law, because I don't believe that in a criminal case that we can do an interlocutory appeal, but that there may be a conditional plea that allows such an appeal. Because I think that he has that right.
He does have a right to do a conditional plea, but here's the point, Mr. Poindexter. The owner of the car was told that the car was there.
Yes, sir.
And he goes over there and he recognizes a car. That's enough to put it on the location. And the owner can recognize it since he had it towed by the VIN number and everything else, and not only the rarity of the car. Now, the other two vehicles we haven't talked about here yet. We've just talked about this car.
Yes, sir.
So but one car is enough, probably, if you got one stolen car on there.
Right.
And then you got these other cars that are some distance, it appears to me, and could very well not be in the curtilage. So that will be my ruling also, that this car would, I'm not going to make a determination whether it was because of inevitability of discovery of the thing, but I am, out of an abundance of caution to protect your client's rights, I'm not going to let the sheriff testify that he did the VIN number there at the location and identified it specifically.
Well, and so are you suppressing the other two vehicles?
Nobody brought the other two vehicles up to me. But I don't know, I'm not suppressing the other two vehicles at this time.
Okay. So, just to make sure, if you're referring to Ms. Gordon, if she is going to draft this for you, that it make reference.
I draft it myself.
Oh, okay.
I just had it, a lot of times I let lawyers propose things that are on the prevailing side. It's just been the practice here. She's not going to draft anything for me. She would be proposed, but now don't do anything. We'll draft it. Well, It'll be different, because if we didn't like the proposal, my staff lawyer is completely available.
Right.
To do that. Okay. Is there anything else you have?
I just want to make sure that would reference all three vehicles and to what the court's ruling was on all three. So that way we
have any other testimony other than two vehicles, if they were farther away from the house, and that there were 8 or 9 vehicles there. I think 8 vehicles.
Judge, I had contemplated perhaps giving notice of a subsequent or similar bad act. It's just beyond the realm of coincidence that there would be 2 other stolen cars there, both of them stolen from Elkhart, Indiana, and found in a remote part of Monroe County.
If he's referring to 404B evidence, Your Honor, he'll need to file notice and give us that enough time for us to, yeah, I don't know that that we can have a trial April 19th. If he's
We're gonna
file
have a
that.
trial April
Okay.
19th, and you're aware of those cars being there. Your client is aware of those cars being there. The cars were mentioned the other day, so.
Right.
You know, I'm gonna let the testimony in. I just have a feeling that the curtilage argument that they're making is a pretty good one. The area around your house that's used for the purpose of living, but you can't tell me that someone can have an open and plain view, a bunch of vehicles laying out there like that. And one of them is stolen, and obviously you're there. You could have exigent circumstances where they could be moved before you can get back or whatever. So I'm going to let that testimony in. Okay?
Yes, sir.
Okay, thank you.
Yes, sir.
That doesn't mean that out of abundance of caution that the Commonwealth might choose not to mention the other vehicles, which would, I won't give them my opinion on whether that would be prudent or not, but it might not be. Okay, well, thank y'all very much for being here. You got something, Sheriff? Thank you, Sheriff. You got something, Sheriff? Okay, now we have any other cases? Yeah, what do you got here?
Your Honor, we are ready on Buddy Dyer and Raymond Garrett.
Buddy Dyer.
You want me?
Adair County Jail.
I guess I see.
Yeah. Why don't you bring the grand jury in? The grand jury, just have a seat.
Okay.
We'll let bring the grand jury in. I don't know where they are. Are they downstairs? Let me just run down there real quick. We'll be right to the back to the Adair County Jail.
Hey, can you run back and get a door out of the elevator back there? Come up and get the truth and lay it down. Yeah, just make it come up and open so you can come back down. Okay. All right, thanks.
Oh, they are done.
Yes.
Good. And I've got 3:10, 15 to go on. Here's the list.
Yeah.
Yeah.
Well, I don't know, that Randy just told me I didn't know this. Let me call you back. He said we didn't have the paperwork ready yet. I don't know. All right. All right. Thank you.
Same at your old days. The marks are hard on there, so you need to, so you can all say. I don't know where she was.
When did you go to jail? Sure. And I think this, the paper that's somewhere else, fax machine somewhere else. Judge order you sit down here. We're gonna be.
They're playing Northernville. We played Southwestern.
I'm Mine's old mess.
I've already been in here, copy off hers.
Mine's old mess.
I try to stay up there because I feel like I can concentrate more and get my work done, so my body with a big work.
The whole. He's up 3 times.
Well, there's 2 of them.
Yeah, I know.
I had to look at it yesterday. I called her. Can you explain this to me? Like there's 2 different. Yeah. Like, if this is the one that I first.
I already had it marked out for a vote, and then he called him again. I was like, wait a minute, did I already vote this before? Man?
You'll just back to the jail.
Okay, let's come back to order here. Who have you got now?
Buddy Dyer, Your Honor.
Commonwealth versus Buddy Dyer.
I feel it because I worked 2 days with him. With the grandchildren.
Yeah, you didn't have any help.
No.
Commonwealth versus Buddy Dyer. 21 CR 00135. Are you Buddy Dyer?
Yes, sir.
We're here for a pretrial conference. I understand that you filed a motion to enter a plea. Okay, we're on the record back there, Jesse. Turn your microphone on. I know Clay's in there whispering.
Yeah, I'm having to calm him down, Judge.
Yeah, okay.
Yes, Your Honor, we have an agreement in 21 CR 135.
A motion has been tendered, and I want to ask you, are you currently under the influence of drugs or alcohol?
No, sir.
Okay, state your full name and year of birth.
Buddy Jack Dyer, January 6, 1987.
Are you the same person named in the indictment?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes.
Have you reviewed the evidence which the Commonwealth has against you?
Yes, sir.
Do you believe that you've been fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights in the Kentucky United States Constitution. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak to trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. You have a right to produce evidence, call witnesses in your favor, have process issued to compel their attendance. You have a right to require the Commonwealth prove on a reasonable doubt that you're guilty of the charge against you. You understand that by entering a guilty plea, you have to give up all those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea. Mr. Stockton, what is the Commonwealth's recommendation?
Be upon a plea of wanton endangerment, first degree, 2 counts, and persistent felony offender, first degree, 2 counts. He would receive a sentence on each of 10 years to run concurrently for a total of 10 years. He'd be probated, credit for time served. He would enter and complete the Cumberland Specialty Court. He would receive credit for time served. He'd maintain gainful employment.
Okay, is that your understanding, sir?
Yes, sir.
Okay, has anyone offered you anything or recommendation of benefit to enter this plea? Or are you entering a plea because you are guilty?
I'm entering the plea because I am guilty.
Okay. Counselor, is that your signature? Is his signature on the agreement?
Yes, Your Honor.
Okay, we will accept the plea, offer pre-sentence investigation report to be done by probation and parole. We'll have it back here on April the 28th.
Your Honor, he would be willing to waive his pretrial.
I don't waive them. I do them on everybody. I don't sentence people in the dark.
I understand, Your Honor.
Okay.
What about drug court?
Well, you'll get interviewed by drug court and probably.
He's already been accepted, but they said he couldn't start orientation until sentencing.
Okay, well, you'll probably be right after the 28th that you'll get into drug court. Okay, thank you very much. Okay, well, who's next?
Brandon Garrett, Your Honor.
Raymond Garrett, Commonwealth versus Raymond Garrett. 18 CR 00052. Are you Raymond Garrett?
Yes, sir.
Born in 1983.
Yes, sir.
Last 4 digits, social security number 8717.
Yes.
Okay, I understand you wish to enter a plea today. Is that correct?
Yes, sir.
Is this a felony plea?
Yes, Your Honor.
Okay, a motion has been tendered. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in the indictment?
Yes.
Is your judgment impaired in any way?
No.
Have you discussed the charges with your attorney?
Yes.
Are you satisfied with the advice of your attorney?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
Yes.
You believe that you've been fully informed about this case?
Yes.
You understand that you do not have to enter a guilty plea?
Correct.
You have certain rights under the Kentucky United States constitutions, and I'll read them down to you, and at the end of them, I'll ask if you understand them. You have a right not to testify against yourself. No one will make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to acquire the Commonwealth to prove on the reasonable doubt that you're guilty of charge against you. You understand that by entering this plea agreement, you give up all these rights. Now, I may consider the Commonwealth's recommendation, but I will apply any range of sentence provided by law. I do not have to accept it. Prior to accepting the recommendation, I will wait to pre-sentence investigation report and probation and parole. In the event that I don't accept it and decide to give you a harsher punishment, you have the right to withdraw your plea and have a jury trial. What is the Commonwealth's recommendation?
Your Honor, Mr. Garrett will plead guilty to theft by unlawful taking over $500, receive a sentence of 2.5 years to serve. He'll receive credit for time served. He'll owe restitution in accordance with the restitution order of $2,270. Of course, he can't pay while he's incarcerated. He'll pay court costs at discretion of the court and maintain employment if he's paroled or whatever.
Okay. Is that what you understand the agreement to be?
Yes, sir.
Okay. Pleading guilty because you are guilty of it on your own free will. Is that correct?
Yes, sir.
Knowing your constitutional rights, I've explained to you, it's still your desire to enter this plea and allow me to fix your plea of guilty within the parameters provided by law. Once you do this guilty plea, any future convictions of felonies could be enhanced as for sentencing. You understand that?
Yes, sir.
Counselor, is that your client's signature on the document?
Yes, Your Honor.
Can you sign the document, sir?
Yes, sir.
I will accept the plea agreement order pre-sentence investigation for be done by probation and parole. And have.
Your Honor, I just wanted to
And have the
advise,
sentencing scheduled for April 28th. Go ahead.
he had been scheduled for sentencing last month, and Your Honor, you denied the plea because it was for probation and he had had a new offense. So he's had a PSI that we reviewed last month for that probated sentence. I don't know if that affects the court. We're fine to wait another month. I did just want to advise of that.
I wanted updated and
Okay.
other stuff in there. Okay, thank you very much. Have you got anybody else?
One more, Claude Cole, and on Mr. Garrett, Your Honor, last time we had already signed a restitution order and it has already been signed by Your Honor and entered into the record. So there's another copy in there, but we already have one. So I just wanted
Restitution
to-
order is okay.
Yes.
Claude Cole.
Hey, Judge,
Yes.
that I'm eligible for MRS on this, right?
They say you are.
All right, thank you.
I don't know. They say you are. Claude Cole. You want to put your mask on, buddy? What's he doing? Are you Claude Cole?
Yes, sir, I am.
Okay. This is 22 CR 009. We're here for a pretrial conference. You're born in 1968.
Yes, sir.
Last four digits, social security number 6795.
Yes, sir.
I understand you want to enter a plea today. Is that correct?
Yes, sir.
Is this a felony plea?
It's a pretrial diversion, Your Honor.
Trial diversion. Motion been tendered says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
No, sir, I'm not.
Are you the same person named in the indictment that I just announced a few minutes ago? You're the same person named in the indictment?
Say that again. I'm sorry, sir. I didn't catch that.
Are you the same person named in indictment 22 CR 009, Claude Cole?
Yes. Yes, sir, I am.
Okay. Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir, I am.
Okay. Have you reviewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yes, I reviewed it.
Okay, you have certain rights in the Kentucky United States Constitution. I'm going to go over those rights and don't acknowledge it to the end. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to part of the Commonwealth, prove on a reasonable doubt that you're guilty of charge against you. You understand that by entering a plea of guilty, You give up all those rights. Now, I may
Yes, sir.
consider, okay, now I may consider the Commonwealth's recommendation, but I don't have to accept it. In the event that I reject the Commonwealth's recommendation, and since you're a harsher sentence, you can withdraw your plea and go to trial. Have you been previously diverted in the last 5 years?
I don't understand diverted. I
Have you had a pretrial diversion in any court in the last 5 years?
No, sir.
Okay, have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation or pretrial diversion or parole?
No, sir.
Okay. You understand that if you completely comply with the diversion, the case will be dismissed, pretrial diverted. However, if you violate the terms of diversion and are so found in my court, I'll order a pre-sentence investigation report and you'll be a convicted felon. You understand that?
Yes, sir, I do.
Mr. Stockton, will you give us a recommendation?
Yes, Your Honor. He will plead guilty, Mr. Cole, to possession of controlled substance, first degree, receive a sentence of 3 years, pretrial diverted for 5. He'll also plead to operating a motor vehicle while impaired, first offense, $200 fine and cost. He'll be referred to the Social Service Commission, follow all recommendations, receive credit for time served, pay court costs discretion of the court, maintain gainful employment, and all evidence in this case be destroyed.
Is that what you agreed to, sir?
Yes, sir. Sounds good.
If you have a signed document for him,
I do.
I will approve the document. And you are pleading guilty because you are guilty, is that correct?
Yes, sir, that's correct.
Okay, well, I will sign that. And when can he come and meet you?
Monday at noon, Your Honor.
Okay, if you'll come Monday at noon to the probation and parole office up in Columbia to meet with them, you're not going to be under, you're not going to be on probation or parole, but they keep up with the pretrial diversions also. Okay, so you need to be up there at noon.
Okay, does that mean I'm being released?
Yes.
Well, when would you like to be released?
As soon as possible, that way
Well, then I can do that right now if it's all right with you.
that'd be wonderful. And
Okay. Okay. Well, let me give you a little warning though. I'm going to go ahead and sign the document for you to get out, but you be up there on time and you be sober and don't have any drugs or anything in you because you don't want to get off on a bad foot. I'd hate to revoke you before you get finished, even get started. You know what I mean?
yes, sir, I understand completely.
Okay.
Judge's court costs us $845 and he's got a DUI.
You had a DUI on this case, and I want to remind you on a DUI that'll stack on you too. In other words, if you get just like your felony charge, if it comes over on the DUI, if you get another DUI, it's enhanceable. It'll be more serious each time you have additional DUI. You understand that?
Yes, sir, I do.
Okay, now $845. I'll let you start paying it at $40 a month every month, starting 30 days from your release. Okay, and you can pay it up front if you want to, but $40 is something you ought to be able to handle. Okay.
Yes, sir, that sounds very good.
Okay.
Mr. Cole, I want to remind you, your license is suspended because of the DUI, so you can't drive to Columbia on Monday. You got to have somebody else do that, okay?
Yes, sir. Yes, ma'am.
Okay, thank you. I'm gonna sign the order. And
thank you, Judge.
Is there anything else come before the Cumberland Circuit Court? Not.
Adjourn. Let's just do it.
What's the story?
Sheriff Daniels made contact with Fentress County Sheriff, and he was incarcerated from 316 to 320 in Fentress, and then on 321 he was transferred to Putnam County. But there's no definite how long he was in Putnam County.
Well, we'll just have to transport him. I've got a hold and I cannot ignore a hold.
This, here, this is the holder. It was
You have a
signed
copy of the
March
holder?
16th.
This is the one that was served on me. This is what I went to jail for. This is the one that I served.
It's on March 16th on this one.
Where this is the
This
hold.
will be.
Who would risk on that?
It was returned on the 16th or 16th. The defendant was arrested and placed in custody. Sheriff signed it.
Where, down there?
Down there.
And then they transported him up here.
No, they transported him.
How did he get up here?
They let him up.
What do you think, Sheriff?
This is the holder.
He didn't tell me, he just said, find out how long he's in jail, that's what I call him out. I didn't ask about no hold.
Yeah, over on Tinker's County, it looks like it was served on him on March 16th. It says the above named defendant was arrested and placed into custody. The sheriff or deputy sheriff signed it.
I'm gonna let him go.
He was arrested on the 16th.
He's already been arrested. You be on your way rejoicing. During the next 12 months, unless you're in jail, you're not to wear any orange.
Oh, gosh, I hate that one. I've been so around that woman today.
What do you got to want? Yeah, for the ATV, I would always canvass. Hey, we got to making those little softball teams. If that heat sufficient is sufficient to keep us so, because they're not going to walk into it. If you get a killer, you might not take them out.
There's three. There's Nethery.
Fox will get him out of here. That county gonna lose a lot of money.
Yeah.
7 minutes.
Right there. All that dude said, see when I was in jail, that's what he told me. So you. Huh? No. I was just trying to check it because I had two different ones in my truck. It was a 10-year probation for what? Yeah. There's no just get quieter as he reads. He's like. So Brandon's in Houston. He wasn't probated last month. He was playing front office. So it's further than TV. But it's PSI or pre-trial. 7 minutes. 7. What did he say?
Yeah, we got stuff at one.
Is that what he said, 7 minutes? He says Thompson.
One civil stuff.
I was like, you walked out of here downstairs.
Well, 6 months.
That was. Hey, James, did you run that? Yeah. It's a, yeah.
He got 6 years. He served 6 months, probation surveillance for 5 years. Then he went out of jail. His mom, but she's been evicted.
So he hasn't finished his 6 months.
I think Vega's going to.
With him left.
Let it out.
He's probated. Yeah. He wasn't sentenced yet, was he?
Yeah, he was sentenced last in February.
So he's already had a PSI and everything?
Yes.
Okay. So he needs a probation transfer. So 6.
Next, do you need to think about that one of them, Becky?
No, in that case, it's fine. They're not going here, nobody's here, so one big thing to go back.
Oh, good.
What's all this dust in me? I got CTC update, not her books.
You know what we're doing Thursday anymore, right?
I didn't know.
Cody's leaving. The girl downstairs.
The redhead?
Yeah, she's leaving us. So my days will change. I'll be here Monday, Tuesdays, Wednesdays.
There's not gonna be no females here on Thursdays at all.
We'll only have one officer here, because we, unless find somebody to hire, but even if that happens, it's still gonna take like 2 months or better to get all the paperwork done to get them in here.
That's it.
It's frustrating.
Well, I hate that I burden you, because I mean, I can't also keep your customers. But once they know that I can't do a supervised drug test, there's gonna be a huge increase in BS. So without dragging an officer from another county all the way over here to do that, I want to send them over to the office.
Yeah, that's, well, we were talking about that earlier, and I said, well, let me forget to tell Darren, I might be able to. And she's leaving, so that's the only option we have. We have to feel like, I'll be here 2 days by myself. He'll be here 2 days by himself. So Scott's gonna have to drive, so I just don't know how long it'll be. Hopefully that happens.
March are hard.
Yes, I've got CTC update, not the vote. 138. 22. Joseph, yesterday, I was like, today, so. Well, I had that officer, I was in this today, like, I didn't know. No, I didn't catch it, she told me. To take me. Christian. Scotty Way.
You don't think I have to eat?
Yeah. I think it worked. Yeah.
No, she don't run down, get your paper.
I only got two, and I caught three change. The only one. It came up to me for help. She's small. She's one of the. That's not good.
Do they ever come back? That's what I thought.
Last year, 15 years, been up for blowout. This year, we had one game decided. Every game decided.
And attendance came back. It's such a good term that I. Friday's the best day. Around on Friday, 4 times. Just get up there early and stay all day Friday. Try to stay. You like basketball, just a lot of fun. Good things to take a glance at too. My pleasure.
Don't vote against me.
Question, I hope that's your Richard's class. That's all for 9 years. Still cold, Robert. Torn.
No, it's Roger.
See, I'm what? I go back to cold harness. Broderick. Yeah, I mean, that's. Cold, yes, cold hearted Broderick. Broderick Pierce, and then now it's Broderick.
It's Roger.
What else? They're dead or retired.
Making sure it never will. He just loves those.
Always look forward. Everybody keep your seat. Keep your seat. Let's get some. The child support docket is canceled. One case that was withdrawn by the county attorney's office. The DVO. What?
The jail was on Zoom, yeah.
Okay. Vibert versus Vibert, DVO. Joshua Neal Vibert is there. County jail on the line. Doesn't appear to be. What do you have on this? You gonna need a hearing on this?
Your Honor, my client's wishing to drop the EPO.
Are you, how do you say your name?
Tasha.
Toshua. Well, that's a new one on me. I've heard of Toshua. You're the first Toshua I've ever read. Will you raise your right hand, Toshua Lynn Vibert? Swear the testimony about to give is the truth, the whole truth, nothing but the truth. Tell me why you want to drop this. I've read the DVO. I mean, you made some serious allegations.
Yes. We've, of course, we'll be married to be 20 years in June, and
Speak up.
we'll be married to be 20 years in June. And my parents, have always said, once you get married, stay married. And, they pushed me, with stay in marriage. And I feel like if we do some counseling, it would actually help us.
Did your parents tell you it's all right if somebody beat you or threatened you?
No, they did not.
They left that part of it out. Did anybody force and threaten and coerce you? You feel safe?
Yes, I feel safe.
He's in jail now. How long is he going to be in jail?
I have no idea.
What's he charged with?
Your Honor, if I may, I believe he's charged with felony fleeing and evading. There's 2 counts of that. And he's also got some other various criminal charges, I believe, that's been brought before the grand jury.
Well, I will dismiss it if you insist on it. But let me tell you, I think you need to talk to your attorney about seeking some counseling. It's a good thing to preserve marriage and that sort of thing, but it's also something that you need to have some counseling on to see how dangerous your situation is. I'd hate to pick up the paper and see something happen to you. Okay? Okay, submit an order.
Thank you, Your Honor.
Yeah. Commonwealth of Kentucky versus Martha King. Mr. Upchurch, you got your microphone on?
Yes, sir, I do.
Hello, Keith.
Hello, David.
What we got going here?
Your Honor, it was up to me to try to locate Martha Keene, and I have located Martha Keene.
I saw her in the grocery the day we were up here. She's at the IGA, so I started to go up, citizens arrest.
Well, that's fine. She's apparently not too mobile these days, but she lives out here across from Charlie Owens'
What are
place.
you gonna do on this thing?
I think Keith and I need to have a real serious talk about what we're going to do, because it's both sides have some problems. And Keith, what do you suggest?
If you want to talk, we're always open to talk, David. I can, if Judge Williams agrees, I can pass the motion and renotice it when necessary. If you want to talk and see if we can work something out.
I'll give you a call in the next few days.
It's always good to talk before you have these things set.
Well, that's right. Well,
I'd rather get here and tell me you want to talk.
Well, I've made 2 trips to Miss Keene's and never could find her, but I got her today. So
Tell me what she drew down how much?
$38,000.
And how much, what are y'all willing to pay her, Keith?
My proof of trial will be 16,000, Judge.
Big discrepancy.
Pretty good spread.
Yeah.
Well, I'll schedule it for the 28th of April, and if we don't have a resolution by then, I suggest on that date, we'll set a trial.
You've got 2 good creative lawyers who can work with each other, so we'll see what we can do, Your Honor. Thank
Okay,
you. I believe that's all I have today. I may be excused.
Nice beard.
Thank you, Judge. I appreciate it.
I'm very envious, as a matter of fact.
I'm doing the caveman thing. Judge, do you want me to submit an order on that?
That'd be great. That'd be great.
Okay.
Your Honor, the Nethery matter, I think the court's aware that the hearing's being continued.
What matter?
Jonathan Nethery.
Well, let me just go down through the docket here.
Well, I was going to leave, but you said you're doing it at the end of the docket, and
Well, I've just got 4 things on here. You got a second here?
Judge, it's not
Yeah.
on the docket anymore. It's not on the docket anymore. That was the 2:30 suppression hearing that you agreed to continue.
Okay, we've already agreed to continue it, as they said.
yes.
Okay.
Back with you on the day. Is that okay?
Fine with me.
Let me excuse.
Absolutely. Have a great day. Philip Capps versus Rebecca Sue Rush. Hello.
Good afternoon, Judge. Kate Payton on behalf of the plaintiff, Mr. Capps.
Rich Alexander on behalf of Ms. Rush.
This is our motion to set for final trial.
Okay, let's go over what we got going on here. Give me a thumbnail of the case again.
Yeah, I can't give it.
Oh, I'm sorry, the case number?
No, just a narrative. Where you are, and what are the issues? Have y'all both filed your pretrial stuff with your issues and who your witness is going to be? I haven't seen that.
Judge, that's correct. Basically, this is a will contest. The complaint filed alleges basically undue influence and that the decedent lacked the testamentary capacity to execute the will. The will was executed on December 8th, 2017. The circumstances that really support both the
Okay.
undue influence claim and the lack of testamentary.
Both of you, I got you.
Okay.
I remember. it now.
Understood.
I had this case confused with a couple others a little bit. I don't. Take 2 days to try this. You think?
We agreed on that. Yes, Judge.
Yeah.
Your Honor, we had talked informally before you called the case, and I think we are both in agreement if it pleases the court to set it sometime the first of next year. We've got some.
Next
Perhaps.
year.
I'm sorry.
Next year.
Yes, sir.
You know what I've always found, you set something next year, a bunch of witnesses might be called to their reward between now and then, you know. But that's fine with me. I don't push things, y'all. Both agree to next year.
Mr. Broderick will be the one trying this case
Oh,
primarily.
we can never get it done in 2 days.
Well, you know, I'll try to rein them in, Judge, the best I can. But the reason why we were looking at next year was most his civil trials are starting back up, so he's pretty booked. I'm sure Mr. Richardson is as well.
Well, he beat me to death here in a will contest case one time, maybe twice, so. I bet sometime is February far enough into next year.
That's exactly what we were thinking, Judge.
Yep.
Okay.
Judge, motion days would be the 9th, 16th, and 23rd.
Is President's Day a holiday here, Megan?
No.
How about the 6th and 7th of February?
That works for us, Judge.
Yes, sir.
Yeah, and we were talking about some various pretrial deadlines for like conclusion of discovery and expert witness disclosures.
Oh, you haven't done that yet?
Well, we have, but I guess just.
Well, unless you tell me that you got all that done, I'm not gonna set a trial, so.
Well, I think the discovery is pretty well complete.
But what kind of expert witnesses you gonna have?
I think at most one medical professional to talk about the decedent's physical and mental capacity.
You want to depose that person, what you?
Yes, sir.
Well, y'all need to get that started, okay?
Yes, sir.
Trial.
If it's suitable to your honor, we can circulate dates amongst ourselves, and if we can't agree, then
I'm
perhaps
sure
the
you'll be able
court
to
could
agree.
enter a trial order.
I'm sure you'll be able to agree. But you can always contact me if somebody's being destructive, I guess. Okay.
And your honor, we have not mediated this case. I don't know if it's your practice to send cases to mediation by order, if that's just.
Let me tell you what, if people request mediation, I'm all for it. But there's no reason to mediate cases that there's not any room in. So I've got a couple, 3 people. I mean, Dodie George does a great job.
Right.
I think he's moved to Lexington, somebody told me.
I think he has, yeah. We can
But-
talk about that. I'd be fine
But
to
he
use
can
Judge
come back, yeah,
George.
Justice Lambert is available,
Okay.
you know, so,
We'll work on that, Judge.
okay,
Thank you very much, Judge. That's all I
Have a
have.
great day.
Thank you. Thank you.
Finley versus Finley.
Mr. Finley, I think Ms. Caps is on the way from Metcalf County. She had to work there. She texted me this morning. and said so.
What is that about?
It's motion to show cause for failure to respond to discovery requests and interrogatories.
Who failed to respond, her client or your client?
I'm sorry.
Who failed to respond, your client or her client?
No, my client filed on December 8th,
No, who failed to respond,
the defendant, the respondent.
her client? You can't reach an agreement on that when they got to respond back?
Well, we tried to do that. We waited like a month and a half and kept inquiring, and then we filed this.
Well, I don't know. I don't know whether I'm gonna wait. I don't know when she's gonna come back.
She's on her way. She texted me about 30 minutes ago, so she's on her way.
Well, she ought to be here any minute then, so, okay.
And we want to let her, she texts, the extension like that. We did about that.
Okay. David Gross versus Courtney Nicole,
There's an agreed order.
Thacker agreed order. Okay, that finishes the civil docket, except for the one case. Right? So we don't have anything for another hour till 2:30?
We had it, 1:30, we had it back county chop.
Madam County Attorney, are you ready for the Dare County Child Support?
Yes, Your Honor, I am.
Okay, I'll call the case. This is Adair Circuit Court meeting in special session in Burkesville. I'll call the docket. Coffee versus Coffee, 13 CI 00163.
Your Honor, after we filed the motion, she paid the amount in full, so we can remove that from the docket.
You send an order that effect would be good. Tara
Thank you.
Dean versus Alan Sparks.
On Mr. Sparks's case, we're asking for an order to show cause for 525 to be paid by May the 26th. He's incarcerated right now, but I'm not sure what his status will be. So we thought, you know, 60 days out, we may know better what's going on with Mr. Sparks.
May what?
We made the order show cause for May the 26th, so we'll kind of know if he's going to be out of jail or not.
Okay, that's our rule day, right? That's what you
Yes,
did.
sir. Yes,
Okay.
sir.
Okay, submit the order. Watson versus McLean.
And we ask for just to review this, in order to review this on May the 26th at 1:30.
That'll be fine.
And we'll, excuse me, Your Honor, we'll send you these orders in just a few minutes.
Okay, is that it?
Yes, sir.
Okay, thank you so much.
Thank you so much. Bye-bye.
for failure to answer discovery. We've agreed to pass this motion
Okay,
for condition upon they get us discovery within.
let me call the case first. 21 CI 0064 Finley versus Finley, is that correct?
Yes, Your Honor.
Okay, y'all have an agreement here?
Well, we're trying to work out a whole big agreement for everything, but for now.
Well, don't be doing that. It put me out of business if everybody agreed to everything. Jeez.
Trying to get finished what we can today. So we're willing to continue our motion condition. They're going to try to get us discovery by a week from
Okay,
tomorrow.
well, let's make sure we get on the record of what discovery that.
Judge, Ms. White had provided us with a request for production of documents and interrogatories. I've given her informal copies of the documents that my client has in her possession, as well as informal responses. But if we could have till the 8th for me to actually type up a formal response to those, because I was just provided them today myself. So that's what we've
What
agreed.
sort of stuff are you looking for?
We just fixed typical interrogatories,
I know typical, but
documents.
I can't make sure anybody responds if you say typical stuff. You need to tell her what you want.
It's listed specifically in them. I don't have a copy in front of me, but it's listed.
We'll get a copy. I got time.
And Judge, for the record today, we have provided my client's W-2s, her information on any stock investments, copies of what mortgage payments she has, a list of all the debts, and a list of various assets.
What's the underlying case about?
It's just property division at this point, Judge.
Okay.
And debt division.
And today we're making a little bit more successful efforts at communicating about
Yes.
some things and getting a little closer, I think. So I think if we give them until the 8th to
To
complete,
get what?
to complete the discovery.
To get what? What do you want by the 8th?
The request, I didn't bring a copy with me. Obviously, I've left it in the other file.
Let's see if there's-
She had made allegations. One thing I recall is some,
Wait a second. I don't want to.
And Judge, if there's no copy in the court file, I do have my copy today. They were filed back in December. That helps just.
December 8th.
Yes.
Yes, December 8th.
So those absolutely look good.
None of these answered.
Last night she sent me some documents and today she's brought me something
So
in.
what you're telling me is you can't discern what has been and hasn't been answered. So once you get these documents and apply it to this, then you can tell me what is deficient. Okay, well, I'll let y'all work through that thing. So
Yes,
I'll continue it generally. Y'all can renotice it, okay?
thank you, Judge.
Yeah,
Okay.
and in the meantime, if we don't reach an agreement, we'll do you want us to get a date with the commissioner?
Well, then, how much stuff you got, I think you probably get an agreement. You probably get an agreement,
I'm
There's
saying
no child custody things, I mean.
we hadn't made any progress at all until maybe today.
Well, do you want to mediate the thing?
I'm not opposed to that, Judge.
I think if we just had a couple weeks.
What
maybe a
I
week.
think if we could just schedule a mediation out in the future, then that way, if we've not
Well,
resolved it.
here's the thing about it, is the longer you wait, somebody's got a hold of some of the property, somebody doesn't have a hold of property. The greater possibility that an inequity will be done, the longer you wait. So, I might order it to mediation if you don't have something soon. Y'all have mediators you like to use?
I like to use Judge George a lot.
Somebody told me he moved to Lexington.
He has, but he's doing his mediations by Zoom still.
Man,
And then there's, I'm trying to think. what is-
Justice Lambert does some.
You think we needed it for today?
I don't think we do, but if we need something to hold over our heads to make sure our clients are still moving forward.
Hey, I expect to hear from y'all soon.
Yes.
Hey, let's go off the record here. Civil action number 18 CI 0070. Lee Matea, Allen Watson versus Barish and Roach. Let's try to define the parameters of what we're here for today. What do you believe we're here for today, Ms. Katz?
I believe we're here to enforce the mediation agreement we reached back in October.
Yeah.
And to have that actually sit down as an order, Judge.
Mr. Meredith?
Judge, your previous order from March 1st had indicated what objections there were to the draft of the mediation order. I filed that on behalf of my client. I did not participate in the mediation on October 25th. When I finally got a draft of it from the petitioner's counsel in the middle of February, some 4 months later, I sent it to my client and he sent back to me the things that he said was not the agreement that was reached. So that's the objections I filed on his behalf.
And Judge, I have Mr. Roach's former counsel that was actually the attorney that represented him and was involved when we reached the mediation agreement, ready today as a witness to testify what the agreement was.
Well, it looks like I signed the order on February 28th, 22 without signature of Mr. Meredith, or that's the order we're talking about. It says mediation order.
Yeah, I do believe you did sign it, Judge.
Yeah. But you were listed as counsel on there, but obviously you didn't sign it.
I didn't.
Yeah. When did counsel change?
Judge, from my understanding from speaking with Mr. Brown, that it was very shortly after the mediation, maybe within a week after mediation.
I didn't enter appearance, I think, until the first week of December of 2021. So if the mediation took place October 25th, it was at least 5 weeks after. And at the time I entered my appearance, there wasn't any confirmed mediation order that had been tendered to the court, nor had there been one signed by the court.
Well, let's try this. Let's go through down the, rather than look at everyone's pleadings and what they've written and all that sort of stuff. Let's go to the, as the backbone of the situation, the mediation order is entered, and see what's objectionable to that and that. I can't find this. Mass. Probably folded it up in some kind of. There it is. Do y'all have a mediation agreement in front of you?
I do, Your Honor.
Yes, Judge.
Hey, can your clients look at it?
He's here looking at it with me, and I've got the, on my copy of it, I've got the parts marked that were objectionable to him, so.
Well, that might help us go along. Okay, neither party nor the neither the petitioner or respondent shall have any violent, harassing face-to-face communications, including letters, facsimiles, electronic, handwritten, voicemails, social media, other kind of evidence with the other party except as necessary for specific communication regarding the party's minor children. Now, neither one of you would disagree with that, would you?
Judge, the only thing that was left unanswered was there's no objectivity as to what's supposed to be a violent or harassing face-to-face contact.
Kind of like pornography, isn't it?
Yeah.
You know, when you see, how would you suggest we define that?
Well, I would obviously indicate that if there was some type of contact that one party or the other objected to, that they make that known to the person that is objectionable in their face and say, if that continues, then we'll have a hearing on whether this does or doesn't constitute something that's violent or harassing. I mean, from time to time, these parties, from my understanding, have gotten upset with one another over the littlest things or the greatest of things. And I don't want that to be considered to be violent or harassing just because they're upset. But you're right, it's a Potter Stewart kind of situation. You don't know it until it occurs, and then how you're gonna handle it is, I just don't want there to be some kind of unilateral assumption on behalf of the petitioner that a text message that my client sent after receiving a notice from her that she's canceling a visitation because the oldest daughter's got a birthday party that she didn't bother to tell him about.
Well, I don't want to get a bunch of testimony, but I don't know any other way. Until these children become 18, I've resigned myself to the fact that we'll constantly be involved in this thing. So it doesn't really help definitionally other than just what most people know what will be violent or harassing. And I anticipate that we'll continue to have motions on this thing until the children are 18. So I don't know of any other way to handle it other than the way it is.
Judge, just to give the court an example, and he sent this to his own daughter.
I don't want to get examples.
I'm just saying.
I don't want examples. I don't want his example or your example. I've read these things for years, these communications back and forth. And quite frankly, a lot of them are disgusting and juvenile. Why these two people can't leave each other alone, I do not understand. But I do understand that some of the things, especially Mr. Roach has said, had been very offensive, would be offensive to anybody. And I don't like some of the things that Ms. Watson has said. So, but let's go to number 2.
Judge, I don't know what this Talking Parents phone app is, but.
Could you tell us what that is?
Judge, that was an app that was suggested by Mr. George, our mediator.
Yes.
I'm fine if we want to use the app Close, I think is a parenting. It's an app that has their schedule in place. They communicate through that app and it tracks it. And so there's a documented record for everybody to see. And then that way, there's no back and forth between the two of them. It just gives more control.
What do you have to say about that?
Judge, I've never used it, so I don't know what it's about. My client says he's not even familiar with it. I don't think it's anything the parties have ever used. So I don't really know.
Well, I'm familiar with it. And a lot of people that do domestic, a lot more domestic work than I do are familiar with it. Because you're not familiar with it, what it does is it puts structure on communication. And it's not a he says, she said, they says, it's structure, every communication. And that is the way they communicate with each other. They don't send notes or this or that. And that's the way you understand, Ms. Capps, that every communication they have is written down and communicated. And that way we won't have to worry about going to different locations to see what mode that they use.
And like I said, I know it in Barron Family Court and Metcalf Family Court, they're also using what's called app Close. And the judge is ordering that there in several of the cases. So, we're fine with either one of those parenting apps.
Well, take your mask off and tell me the second word on the app. What?
App Close, APPCLOSE.
Close.
And my client says because of the cell service, it may or may not be something that would be easily usable, but he's amenable to trying it if she's going to use it.
Well, I tell you what, if they use it, it'll help us to find number 1 pretty easily because we'll know everything.
And I'll put an okay back.
Okay, drug testing. Now, I think that your client has drug tested successfully. And so that no longer needs to be in place.
Is she going to reimburse him the $109 for the cost
Judge,
of
that
the
was
test?
our agreement and our understanding.
Yes.
Okay.
Okay, let's go to visitation. That is number 4 would be void because he did submit to the drug testing, correct?
Yes.
Number 5, any and all exchange of the children shall take place at the Dollar General store on South Highway 61. I'm glad you defined which Dollar General store, because there's one on every corner now. Is that agreeable to everyone?
Judge, the disagreement we have on that, that takes him 15 miles out of his way to pick these children up. We're going 9 miles past their house, from his house coming to Tennessee, when it's just as easy. There's a lot easier places, and they have used closer places.
You want to suggest one of them?
Sure. Which one you want?
The store where we've been doing it the last 2 months.
He said the store where they've been doing it the last 2 months. What's that name?
I don't know where
I'm getting ready.
I don't know where the store they've been doing the
Hey,
last
Judge.
2 months is.
Pee-wee's
That's like-
Market.
Just so that the court is fully
P-Rig.
aware of why we reached this agreement of this location and mediation. They're talking about the Pea Ridge Market, which is across state lines in Tennessee. Tennessee will not enforce anything in Kentucky.
No, we're gonna do it at the dollar store. I mean, that's, you can come up there and buy groceries while someone's there and not have to pay sales tax on it, so. that's
Judge, why don't we suggest this? If they're going to insist on him coming up here to South Highway 61 in Burkesville, 15 miles from his house in Salina, to pick him up there, then she ought to go back there to pick him up at his house.
Judge, part of the reason why we agreed.
I'm
to
not
that-
gonna argue about this. It's gonna be at the dollar store. Because it's a well-traveled place. It's public, it's well-lit. Everybody from these communities down there go to that place. It's well-attended. That's not worth arguing over 4 minutes, okay? The respondent shall have visitation with the children every other Wednesday from 3 p.m. until Thursday at 8 a.m. and every Friday from 3 p.m. until Saturday at 9 p.m. Is there disagreement about that?
Yes, I mean, Judge, this is half of the time that he had under his order that had been entered from December 12, 2018. He was getting 2 nights each week and weekends.
Okay, this is one that will allow his previous attorney to testify and see if you agree with that. Okay. Summer visitation. What's disagreeable about this?
Well, usually under the rules.
I'm not talking about the rules.
Okay.
I'm talking about if he agreed to this, what does he now object to? We're not going to relitigate this,
I know.
Mr. Meredith.
I understand, Judge. He should have 2 consecutive weeks, twice a summer.
Okay, is your client willing to say under oath that he did not agree to this?
Yes.
Okay, well, I'll give him that opportunity. So what we'll do is we'll have testimony from his previous attorney about whether this reflects the agreement or not. Who was the mediator?
Mr. Douglas George.
Okay, we'll get Judge George involved in it. We'll write a letter on these 2 things. Number 8. Each party shall be responsible for transporting the minor children to and from any extracurricular when the children are his and her possession. That's no problem, is
That's
it?
no problem.
Okay.
9, 10, 11, and 12 are no problem.
You agree with that? 13. Surely that's no problem.
That's no problem how it's drafted, but there's nothing implied that she is giving him notice as to who the counselor or counselors may be.
Judge, the children have been seeing the same therapist that is the school therapist that.
Well,
comes
here's what we
between.
need to do. That's just like saying where they always meet. If there's a change, this gentleman has a right to some kind of notification of that, so he can be involved and informed about therapies and everything. So that needs to be redrafted. Neither party shall dispose or inquire of any counseling discussions with the children. Well,
That's what is so that they're not
That's
talking to the
good.
children.
The parties shall discuss any and all therapy disclosures about the children directly with the therapist. Now, let's get to notice of therapists, what Mr. Meredith is talking to. Both, and I think you need to add there that both parties shall disclose any provider who is providing medical or therapeutic services to the children, to each other. Okay, they shall describe to each other. Now, what are the therapists that we have now are provided at the Cumberland County School District? Is that where they're seeing them?
It's through the
Is it a
Family Medical Center or the Family Medical Centers.
What is the Family Medical Center?
Dr. Lloyd's office, they have a contract with all the schools through the Healthy Kids Clinic where they provide a therapist.
Let's just say that the therapy shall continue with the entity that is under contract at the Cumberland County School System, and that neither party shall get additional counseling. Either mother or the father should get additional counseling unless they can come to an agreement on a new counselor. That way we have a neutral entity choosing the counselor. You understand what I mean? The school system is choosing counselor. So if Mr. Roach wants to get another counselor or she wants to get another counselor, then they're going to have to sit down and talk about that. And if they need to come to the court to talk about it, that's fine. But, you know, I believe sometimes children can get counseled to death, you know, and I want to make sure that that doesn't happen. Okay.
Judge, on that issue, just so that full disclosure, my client just advised that the school therapist had recommended an appointment, and I think it's April the 12th, with a psychiatrist through the school. And so.
Well, that's under a contract person.
I just
She
wanna
needs to
make
give
sure.
notice of him that the school, that's what the recommendation was. And if she's not choosing the psychiatrist, if there's any element of choice where either one of these parties chooses someone rather than follow who's under contract, I want them to consult with each other. Okay, let's go back to the summer visitation thing. Each parent shall have two non-consecutive weeks of uninterrupted summer visitation each year. Each party shall give the other 30-day notice of vacation plans. Summer school necessary for children to pass the next grade must be attended. General itinerary must be provided for the other parent if vacation will be out of town. Each party will provide phone numbers and addresses for contact during extended vacations. Now, will that be necessary if we're going to be in contact through this app?
No, I think that the scheduling will take care of that through the app.
Okay, so we can take D out. See what I'm saying, Mr. Meredith?
Yes.
I'm sorry, Judge, B or D?
D as
D.
in dog.
Okay.
Okay, this next one, each party shall be entitled to reasonable and liberal visitation during that. I think that needs to be, there needs to be more specificity, because reasonable and liberal does not cut it. It's when people can't get along with each other. So what would you suggest when they're on vacation time as far as allocation of FaceTime and telephone time to each one of them?
30 minutes to an hour
A day? That'll be fine. And that shall be agreed upon between the parties through the app, taking into consideration when's the most convenient. If Mr. Roach is taking them to a performance at Dollywood, I don't want them to have to stop the performance at Dollywood and come out and do the thing. So, I mean, before they leave, they need to have those times set down that would be reasonable. Okay.
Judge, I think it would be specific enough if we just said that each party would be entitled to one phone call a day while the child is in the possession of the other parent. And then that way, because when you're on vacation, you may
Well,
not.
I
have the exact time.
anticipate that it would be good for the children to call. They're old enough to
Yes.
call now, rather than the parent initiate. And that way, the child or children could be able to accommodate the schedule they're on, if you understand what I'm saying, that, you know, when it's time. And so now, other than these changes, what are the problems with the summer visitation, Mr. Meredith? In this pretty, each y'all have 2 non-consecutive weeks of uninterrupted summer vacation, and each party shall give the other party notice. Now, other than that, what differences do we need? In summer
Well,
visitation?
Judge, when we were going under the December 2018 order, he was getting half the summer and she was getting half the summer. I mean, there's 8 weeks in the summer. This has only limited him to 2 one-week periods. I mean, he's a father and he ought to be entitled to.
I'm just trying to find out what he does. I understand. You don't think that number 7 doesn't keep number 6 from being in place?
No.
He's getting all the same visitation in the summer that he gets all the other time, except he's guaranteed these uninterrupted periods. So as a visitation, he shall have the minor children every Wednesday from 3 to 8, every Friday from 3:30 until 9 the next day. I mean, the visitation is the same.
Well, but he's missing out on a Saturday night, overnight.
Well, what do you suggest as far as you want to lengthen these other visitations in number 6 during the summer? Somewhat?
Yes, and I mean, he was getting every other weekend.
I don't care what he was
Okay,
getting.
well,
I'm talking about now.
Sure, I understand. If you're looking at this in a vacuum, this is not enough time for a father to spend with his children. He's only
Even
getting.
if, what I'm saying is, and that's your opinion, and it has validity, you know, as you're saying, what I'm trying to do is get to a resolution of this
I
thing.
understand, Judge. You know, the time during the week could be all right, but every other weekend needs to be included in 7. And all he's getting is every Friday from 3 until Saturday at 9 a.m. I mean,
How do you
that's
feel
less than
about
24
every other
hours.
weekend?
Yeah, that's fine. She says she's fine with
Yeah,
that, Judge.
that's a reasonable request.
During the summer, yes.
So what you do is you modify number 6, and then on that Friday, instead of Friday, brings the children back on Monday. That gives him 4 days, Friday, Saturday, Sunday, bring them back on Monday.
All right.
Judge, but the way this was worded is he was getting a day every weekend. It wasn't every other weekend like they've argued.
Well, what we're doing is giving him every other weekend.
Yeah. And not the
Okay,
Friday
and I'd
weekend.
say, do you take
No.
the kids go to church with you?
Yes.
Okay, well, I want them back on Sunday to go to church. Okay. Do you take them to church too? Where do you know, y'all don't go to the same church anymore? Well, every other weekend, I think is reasonable. So how should number 6 be worded?
They just put every other Friday from 3 p.m. until Monday at 9 a.m.
But if you do it at 9 a.m., is he going to be bringing them back to Kentucky to take them to school? I mean, that's the
Well,
issue, Judge.
We're talking about it for Sundays. We're talking about for summers. This is a new paragraph for summers. Okay, we're going to leave this paragraph
Leave this for the
intact,
school
and then
year.
we're talking about summers.
Okay, sorry about that. So insert paragraph. I'll have to be at work then.
So on the every other weekend, he's going to get the full weekend. And I think that's a fair resolution of that.
And we do Monday at 8 AM because she has to be at work actually at 8 AM. So she's gonna.
I don't care if it's 7 a.m. It doesn't bother me. That way both of them might have to go to work and they can do the exchange. Okay, now what was the other issue?
The
Extracurricular activities?
now the amount of time during the summer.
We just took care of that.
Okay, all right.
He's getting every other, in addition to what is listed down here as far as these 2 consecutive weeks.
Okay.
He's getting every other weekend more than the regular visitation he gets the rest of the year because they're out of school and he'll want to do some things with them.
Okay.
Now, I'm gonna go down to the extracurricular activities. And I'm not around. I go to a lot of high school things and everything, but I'm gonna tell you, these little kids, if they get on traveling teams or this kind of team or that kind of team, is in addition to the Little League or all the other things there, I mean, they're going somewhere all the time. And I don't know how involved these children are, but what are we going to do about that?
I didn't think they objected to that paragraph 8, did they?
Well, I know, but it says be responsible for transporting from any extracurricular activities. Who's going to decide what extracurricular activities they're involved in? You know, that's the problem, you know, if you say, well,
I guess the wording we would use is if the girls decide that they want to participate in a sport.
well, how do y'all feel about that? I mean, I don't know. I've never known anybody that was from Ashlock. I've never known anybody that was from Ashlock or Salina or Clay County that did not want their children participating in sports and excel in them. They all want them to excel in them, you know.
He plays basketball and what? Softball.
Yeah.
And he's been coaching.
Well, one of the children is extremely fast. When she was little, I haven't seen her long. Which one of them is that?
That's the oldest.
How old is she now?
She's 9.
She's still fast?
Yeah.
She's a little kid. I saw her, a little bitty kid. She's really fast. So I might. Is there a provision here where she has to play in Cumberland County sports, or that's not in there? It's not in there. Okay. Well, you wouldn't agree with that either. So
Davey Waite's got me under contract, he says.
yeah, okay. Let's just leave that alone and see how it works, okay, as far as transporting, because they are involved where they are. Are they playing sports in Salina or here or both places?
Birdwell is
Right now, right now until they get old enough to make.
Not the only traveling team.
That's where they get traveling ball, I think. Is
Have y'all agreed on a traveling team?
She just does the all-stars and softball, and then she's got a basketball travel team up here right now.
Yeah.
But I mean, she may be in one in Salina
Well,
too
let
at
me,
some
let me
point.
just tell you, to excel in this world, a child has to be on a traveling team. They can't catch up. So y'all will have that to broach at some, you'll have that to decide, but I'll leave it alone right now. But I was trying to anticipate what sort of problems. we might have. Okay, is there anything else?
Judge, I got the changes on the summer of 7. I'm a little confused on 6. What did we change on 6?
I didn't change anything on 6.
Okay.
That's for the regular year, time through the year. And then we added to 6, a new one that gave him this extra weekend time through all the way through the summer.
So during the school year, he's only getting a Friday night overnight?
No, it says every Wednesday.
Well, that's.
Every Wednesday and every Friday.
And it's supposed to be every other weekend. I mean, Judge, he was getting 2 nights.
I'm not talking about what he was getting.
Well, I'm just trying.
I mean,
to
they
compare.
claim that they agreed to this, okay? So I don't know whether they did or not, and I'm taking this as a base document to try to reach an accord.
Sure. So during school, 10 months a year.
No, not really.
Well, let's call it 9. During school, 9 months a year. So for 9 months a year, I don't think that Mr. Roach would have agreed to limit his week contact to 1 overnight less than 24 hours, and one Friday night, when he was getting 2 nights during the week and every other weekend.
Well, he's getting two nights here.
Well,
So he would have lost every other weekend.
Yeah, okay, so that's why I'm saying that I don't think it was intended to only be Wednesday from 3 until Thursday at 8, because that's one overnight during the week. And then only one overnight on Friday, when he was getting 2 weeknight visits. They weren't overnights, but there were 2 of them, and he was getting every other weekend.
Judge, that's the problem. He wasn't getting those. They had filed a motion to increase timeshare, and that's why we set up this mediation, because they couldn't agree to that schedule.
But it was already in play. The order that was entered December 18, 2018 gave him 2 nights during the week from 4:30 to 8:00 p.m. and every other weekend.
Well, I'm looking at the motion that his previous counsel filed on October the 16th of 2020. It says, that references that 2018 order, and they weren't following that, so your client filed a motion to increase that timeshare, because the parties they were having problems getting orders back and forth. Before I got involved, they were in the court fighting over the timeshare, so that's why we mediated the case.
Well, I'm sitting here, the order's not ambiguous. It says he was getting 2 nights during the week from 4:30 p.m. to 8:00 p.m., and he was getting every other weekend. In fact, sometimes he was even taking them back to school on Monday. That's what paragraph 2 of that
They
order
weren't, that was the problem. They weren't following that order schedule, so she had a counsel that filed a motion regarding that, and then later on, his counsel filed a motion, because they had been in court and there'd been things stated on the record. Because he himself did not follow what the original schedule was in the order. Because he could not get the kids to school. That was the issue. With his employment, he wasn't able to take the kids back and forth to school. I mean, why would his counsel need to file a motion arguing to get every other weekend and 2 days during the week if that's what he had been exercising?
Now, he wanted more than that, but.
Okay, how does your client feel about every other weekend?
That's what we're doing now.
Is it okay?
Yeah.
Okay, well, we'll just make number 6 apply.
All right.
All year. You'll add every other weekend on that.
And then if that's the case.
But I want the child back on Sunday night.
Thank you, Judge, that's what I was fixing to ask.
Okay. Every other weekend, but have the child back on Sunday night.
Sunday at 8.
Okay, now, what other disagreements do we
I
have?
thought it said PM, Sunday night.
No, he said he was.
Okay,
Judge, can we just set the exact time so there's clear on the record?
he said 8.
8 PM.
So then Friday at 8 PM to Sunday at 8 PM. Okay.
Well, why would you want to wait from Friday to 8 PM on Friday?
I'm just trying to make the times
Well, okay,
consistent.
let me give you a time. Let me give you a
That'll
time
work.
at 5 o'clock on Friday.
That works, Judge.
Okay,
Just so that
way
they've
you can
got a
still do
consistent
something on
time.
Friday, okay? And then at 8 o'clock, it got time to bathe them and get them settled down, get them to bed and ready for school the next day. Okay, now, what other issues do we have?
I think that's wrapped it up.
Okay, now, okay, are y'all okay with that? You okay with that?
Yes.
Okay, and are y'all okay with that?
Everything, yeah, he's okay with all the times. He's still a little upset about the drop off, but you know.
Well, if that's the worst thing that happens to anybody during the next year, then they've had a blessed year with all, with everything. But here's what I want to do. And I don't know whether this is possible. One of my friends, older friends, passed away a couple of weeks ago. Leonard Lawson, you know who Leonard Lawson was, big highway contractor. And they're having his visitation this coming on the 9th. And they called and asked if I was going to attend. I said, yeah. And they asked who was attending. And they said, well, the governor is attended. And his father, the former governor, was attended. They were the worst mortal enemies that Leonard Lawson ever had. They tried to get him sent to the federal penitentiary and everything else. But when Leonard was dying, he found out he was dying. And he said that he wanted to make sure before he died that he made it right with everyone that he'd had conflict with, whether it was his fault or not his fault, that he wanted to make amends. And what I'm asking y'all to do, when you leave here today, just leave this animosity on the table. It's hard to do. There have been a lot of things said. I've read a lot of things said, and a lot of other people said this and that, and I've read it all for a long time. But for the best interest of these children, we got to leave it on the table. And you got to, you know, it's hard with someone you've been in a relationship with and had children with to do that. I'm asking you to try to do it. I'm going to tell you it'll pay dividends in the future, because little girls especially need their mom and their dad. It's important for little girls to have both of them there. It's important for little boys too, but you know, it's important for a father to show leadership to little girls that he loves them without demanding anything from them. You know, it's an unconditional love, and a mother is just close to children, you know, and I know what the law is in Kentucky now, but I've observed all this stuff down through the years. So let's try to do that. And if you get a little inner voice that's telling you want to say something to each other, try to refrain from doing that. Try to refrain from doing that. It's not the good Lord talking to you when they're trying to get that. You know what I'm saying? Okay, well, you're going to draft this up and get it back, and the parties, as we have enunciated it, have agreed to it, and maybe we can get a new fresh start on this thing. Okay.
Just a point of clarification.
Yeah.
If the event that she calls him sometime or sends him a text and says, I'm agreeable to another location to pick up or exchange the
She
children.
doesn't need
is
to
that
call him
acceptable?
except through this app.
Okay.
Okay, if they could contact through this other app, he might contact her through the app, he contact through him through the app, and then they need to reach an accord on the app. There don't need to be any conversation. The conversations between these two devolve pretty quickly, you know.
Can you tell us which app she's gonna use? Because he hasn't downloaded any apps yet.
Do the app close? Yeah, let's do the app close. It's the most recent one. App close. Mhm.
Is it CLOSE?
Yes, and I will send you this link that I've gotten
Okay.
by email. And then Judge, I was gonna ask, this order that I'm modifying, can I just have it where both myself and Mr. Meredith sign it? So
Absolutely.
the parties are not.
Absolutely.
All right,
And
thank
I'm
you.
sure neither one of you will sign it without the board of your. Okay, thank y'all very much. Good luck to you. Tawana Gale Scott versus Eddie Brandon Scott.
And Judge, before we take up the other case, can I have just a quick 2-minute break?
Let's make it a quick 2-minute break.
I'll make it quick. if we could take her up first.
Well, I want to set the parameters of what we're
Okay.
doing here, okay? The primary purpose of this hearing is to limit the contact that the respondent has with the children. Is that correct?
Yes.
Could you make a general statement?
Judge, we had previously asked for the court to consider giving my client sole custody and to continue to restrict his contact with the children, given the fact that we do believe he is a danger to the children and his lack of instability and consistency and great extended periods of time that he goes without making efforts to contact the children and his lack of consistent payment for child support, that all those factors go into play. And the fact that he has basically tried to avoid disclosing a residency that was accurate until sometime toward the end of 2021,
Okay.
after we had to go through numerous steps.
What do you have to say about this?
Your Honor, I think you should summarily dismiss their motion to cease all contact. They misstate the burden that they have to meet. They use best interest of the child. To cease all contact and go for sole custody, they would have to show that he would seriously endanger the children, and the pleadings don't do that at all. They say that he doesn't pay child support. Child support and child custody are two completely separate issues.
I understand that. I'm going to hear testimony to see what I believe, where they meet the burden. I understand what the burden is. What does your client have to say about it? He's going to testify in a few
Yes.
minutes. Well, I'll just wait to hear what he has to say.
I would ask.
What kind of visitation does he have now?
He gets to see the children whenever Tawana and her father.
Does he have any set visitation now?
No.
We've had set a schedule pending this hearing, Judge, and he's not been consistent even on a limited basis for that.
I don't want a criticism of whether he's following. I just want to know what is it now?
He had been seeing the children.
I'm not saying when he's been seeing it. What does the order say that the visitation?
The order just says that he's to have visitation with supervision by her father. There was not a schedule put in place.
Okay, and so he's wanting some certainties. Is that
Yes.
right? Okay,
Before we get started, I would like to get all of the witnesses out of the courtroom.
Yeah, I was going to ask the same for the rule.
ask for the rule, it'll be applied, both parties shall enforce it. So you want to call your witnesses that you're actually going to call?
Yes. I will, of course, be calling my client, Ms. Tawana Ray, her father, Rondell Ray, who's the current supervisor, as well as Mr. Scott's mother, Rhonda Hooks, Mr. Scott's sister, which is Cheyenne, that's her, Denny. Sorry, I didn't have my list right here handy. And then also Mr. Scott's aunt, Deborah Rice, and then the children's therapist, Joy Turner. And then his stepmom, Connie Scott.
Okay, who are you going to call?
I'm going to call Brandon, his wife Linda Scott, and his two stepchildren. In terms of their witnesses, I'm going to object to all of them.
How old are the stepchildren?
15 and 18.
You're going to object to what?
All of their witnesses except for Tawana. They filed their pre-hearing disclosure deficiently. It was less than 48 hours before our hearing today. They didn't give any notice on what the witnesses would even be testifying about. No addresses. The compliance is wholly deficient.
Judge, they didn't file theirs until the 29th, or I'm not the 29th, I'm sorry, until this Monday.
Get your calendars out, both of you.
And I'm okay with not having his current wife and stepchildren testifying if.
Well, I'm not going to have a hearing and exclude all the witnesses in it because that, if there has, both of you have a right to a little bit more notice than you've given each other. You know what I'm saying?
Yeah.
And a lot of, when I was practicing, I felt like some people played gotcha all the time.
And we filed ours last Friday.
It's okay. I'm not criticizing you. I just don't want to feel like anybody felt like they didn't get a full opportunity to prepare for it. And because you missed a line or something like that, I mean, I let people do it even in criminal court that meet lines all the time. I do it all the time. I don't like it. But when they leave here, I want everybody to feel like that they had a full hearing and everybody that wanted to testify and that they had that your client feels like that you had an opportunity to anticipate who they were and research what they might say with him. Okay, so let's get our calendars out. I'm not talking about a long way in the future. What are y'all doing next Thursday?
On the 7th, Judge?
7th.
I have a custody hearing in Taylor County that starts at noon.
I'm filling in for Mr. Dodd today, so I need to look at his calendar. I'm sorry.
Well, have you got access to his
Yes.
calendar? Okay. Let's look at the 13th. Now they have district court here on the 13th, but we have a hearing room downstairs that's plenty large enough to take care of this.
Is there any way we could do this by Zoom?
Do what?
Is there any way we could do this by hearing by Zoom?
I'd rather not.
Okay.
We could do that by Zoom, but you know, during these things, I think I know we have these rooms, side rooms, everything like that, but I'd rather not on this one. Look at the 13th.
That's also their motion day, a district court as well, Judge, and I have the juvenile docket at 1, and I've got a hearing set in an attempted murder case at 1. I anticipate that could be rescheduled.
Well, that's okay. So y'all have a district court in Adair County on Wednesdays too?
Mondays and Wednesdays, yes.
Okay. What about the 7th, Thursday?
So I've got to be in Taylor County for a custody hearing at noon.
How long is it gonna last? I don't want to start this thing in the afternoon. I want to get some morning, give you drive time to get down here in the morning so we don't keep everybody here till midnight, you know. So you pick the day.
Do you have, let's see that. What about May the 2nd, Judge?
I'm not going to go out that far.
Okay. I'm just trying to
These
look.
people want a hearing, and just because compliance wasn't there, I'm not going to take it out 2 months.
What about if we started on the morning of the 26th?
I've got a trial in Clinton County that day. Wednesdays and Thursdays. I've got one day a month that I don't have a rule day on Thursday, okay? This month, it's the 7th. And then I've got 13th, 20th, 27th. I've got stuff on every other day.
On the 27th, you've got,
No, I'm open on the
Okay.
27th.
I've got juvenile court and a special prosecution that I can get continued in Metcalf, but I could get Jennifer, I guess, to cover the 27th in juvenile court if it ran over if we started that morning.
Well, let's start it at 10 o'clock on the 27th, okay?
The 27th. Can we get some type of regular contact schedule until then?
Wait a second. 10 a.m. Okay.
Yes.
Okay, what kind of contact? I'm not going to change the supervision aspect of it, but what kind of regular contact would you be agreeable to? So we'll get something down to it.
Judge, we have been offering every Sunday for a set window of time. Every other Sunday, I'm sorry, for a set window of time for him to come and visit with the children.
What about, and it's just 4 Sundays between now and the hearing. What about us doing it every Sunday? Yeah, what time? What after church or anything like that, in case any of the parties go to church? 2 to 4, something like that. 2 to 4 be all right? 2 to 4 in the afternoon on Sundays.
There's been some issues during the supervised parenting time. The last visit, Mr.
I don't want to go into any allegations. It only worsen things. You want somebody else to supervise?
Well, I would just ask that we would be, Brandon would be allowed to go outside and play with the children. He tried to bring a toy, wasn't allowed to go outside and play. His wife and stepchildren have yet to be allowed to meet the children.
Judge, that would be our request. I think the issue that they're alleging is because the visitation is for Mr. Scott. And until the court rules on the safety concerns that we have with both Mr. Scott and his current wife, we would ask that his visitation be restricted to just him. If he wants to see his children, then he needs to come and exercise his visits with his children, not bring up.
Let's hold off on the issue of parental intertwining here till we get later, and we'll address that.
Can they play outside at least?
Well, sure.
Yeah, my client doesn't have an objection with that, but when he
Now, if
brings
it's
other
raining,
people.
do they still have to play outside or? Okay, well, it's gonna be warm enough for kids to get to play outside. Somebody can sit on the porch up there and the kids can knock around, play outside. Okay,
So just for clarification, Mr. Scott
how old are
himself
these children?
is the only person to come for visits.
How old are
9 and 11.
9 and 11? Well, they don't need to operate a wrecker or a skidder while they're out there though. So you can take them outside and play with them, get to know, reacquaint and everything, that sort of thing. And then we'll have that hearing on the 27th. Between now and then, I would suggest that council, within the restrictions there, I don't know anything about this case, how serious the allegations are, that sort of thing. So I would probably negotiations wouldn't do any good. So but if you do talk about it, it'd be a good thing. But I'll see y'all here at 10 o'clock.
I have one more question.
Okay.
There's currently no order that the telephonic contact has to be monitored. Can we just get clarification that he can talk to his kids over the phone unmonitored? Because right now there's a lot of disruption during his telephone time with the kids where.
What kind of telephone time does he have?
So he tries to call them every
Monday, Thursday, and Saturday.
Monday, Thursday, and Saturday at 7 o'clock. And there's just a lot of chaos, interruption.
They just need to be put in a quiet room.
Because she
But
currently.
now
has
let me
them-
tell you something. I'm going to put them in a quiet room. But the first time that I hear any disparaging comments were made or that anybody was trying to influence their testimony or how they act in this thing, there won't be any more telephone communication.
Understood.
And Judge, just to clarify, we've got a 9-year-old and 11-year-old, and they're on the phone and they're not going to sit still for an hour to talk on the phone.
They're not going to have to talk an hour.
No.
That's the hour he'll call and they'll talk as long as you can keep their attention. Good luck.
And that's the issue, is Mr. Scott's been trying to make them talk for that.
I don't
entire
want you to continue to make allegations. Let's
I know, I'm
don't
just
make
trying to
allegations.
clarify,
It does
Judge.
not help these things to make allegations every time one wants to do something. In this situation, he gets to call them. The children, it can't be over an hour, but when the children want to terminate the conversation, hand the phone to the other one, that'll be fine.
I'm just making sure because, as you know, sometimes it's hard to get children to sit still in that quiet room. So if they get up and move themselves, my client or her father have no control over that.
That's not been the main issue, but I don't want to get into testimony. The issue's been the monitoring.
I don't want to monitor. Okay, just let them talk to their dad on the phone. Now, they're old enough to rat on you. And they will rat on you. So if you try to influence them or say anything inappropriate, it won't be a good thing. I'm not saying you will, but I'm just telling you, it will not be a good thing. Okay, is there anything else? Okay, well, thank y'all very much. And I think this will give a more fair hearing to us. We're adjourned.
Just about to text you.
I figured Thomas Okay, so.
Hey. Very nice.
Let me do one thing at a time. This is one of those things. I got it, yeah, I got to do all that, but I just want to make sure that I don't understand that.